Mr. Okecho Stanley, Mr. Sadok Polot, ULS council members physically here and online, members of Uganda Law Society physically here and online, the staff of ULS, the press, ladies and gentlemen, good morning. My name is Christina Wori, the CEO of Uganda Law Society. I welcome you to the 22nd live weekly press and public engagement. Today, we have two issues to discuss. Issue 1, civil and military separation of powers, a critical examination of the UPDF Amendment Bill 2025. This will be discussed by Honorable Meden Segona, who, like I said earlier, joining us online, Senior Advocate Caleb Alaka, and our very own legal aid, Senior Legal Officer, Mr. Sadok Opolot, who is physically present. Issue 2, road rage, FAQs about Uganda's automated electronic penalty system under the Intelligence Transport Monitoring System. This will be discussed by Dr. Isaac Christopher Lubogo, joining us online, Mr. Stanley, who is with us here physically, and Superintendent of Police, SP Kentare Pamela, who is also physically present. We shall have a Q&A at the end of each session. I encourage you all to participate and make this session interactive. Once again, we thank our ULS members, the public, who always join us online, the press, which has not given up on us, and our special council members. We value you, and we value your presence and input. I thank you. Right now, I invite the head rule of law to come and take the podium and speak to her. Thank you.
Thank you, CEO. Good morning, all protocol observed. My name is Apio Afra. I'm the head rule of law, Uganda Law Society. We will begin today's RNB with We'll begin today's RNB with our topic on the EPS and ITMS. One of the issues that has dominated the public discourse in recent weeks is the implementation of the automated electronic penalty system under the Intelligent Transport Managing System. The Ministry of Works and Transport recently enacted two key regulations: the Traffic and Road Safety Prescription of Speed Limits Regulations 2025 and the Traffic and Road Safety Express Penalty Scheme Regulations 2024. These regulations were introduced with the stated goal of reducing Uganda's alarming road fatalities and promoting road safety through automated enforcement. However, the rollout of EPS has triggered widespread public outcry, especially on social media and online platforms. Many Ugandans have expressed deep concern over the high and, in some cases, excessive penalties with limited payment window and the lack of clear information about how the system works. At about 8:30 p.m. last night, the Ministry of Works put out a communication on their X page that the implementation of automated EPS was temporarily suspended following a comprehensive review. The communication also stated that the Minister of Works, Honorable Katumba Wamala, will issue a detailed statement today outlining the way forward. To help us make sense of all this, We are joined by a representative from Uganda Police Force and lawyers who are also experts to guide us through the legal and technical aspects of EPS and ITMS, to clarify frequently asked questions and to offer practical and lawful recommendations going forward. Our first speaker for this session will be Superintendent of Police, Kentaro Pamela. She is a legal officer under the Directorate of Traffic and Road Safety and has served in the Uganda Police Force for 11 years. Afande, you're welcome.
Good morning, everyone. Thank you for the invitation. Before that, I'd like to stand on the existing protocol and deliver some few remarks. I hope I'm loud enough. As the Directorate of Traffic and Road Safety, we appreciate your invitation to such a gathering, and we look forward to future invitations, because when we get these messages closer to the people, it helps us in spreading knowledge about the work we do, about the different laws that we implement. Before we go into the EPS, the new EPS regulation and the speed limit regulation, I'd like to draw our attention to the road safety situation in Uganda. The number of fatalities in our country has grown by 80.8% in the last 10 years. That is from 2004 to rather 2010 to 2024. And I'd like to make some few distinctions. We have we categorize injuries or crashes into three. We have three categories. We have the minor crashes, which is where a vehicle to vehicle or a vehicle and another obstacle, but no one is injured or killed. We call that a minor crash. Then the serious crash is where there are injuries. Then a fatal crash is where lives are lost. We have been guided that the nomenclature has changed from accident to crashes, because the word accident has an element of foreseeability, and in most of the crashes there's an element of foreseeability of the eventualities, but which is usually ignored. So we now use the word crashes. In 2023, we registered 23,608 road crashes. In 2024, that is last year, we registered 25,107 road crashes. That is the total. So from 2023 to 2024, there has been an increase of 6.1% in the number of road crashes. When we break it down further, the number of fatal road crashes increased from 4,179 in 2023 to 4,434 crashes in 2024. Let me pause a bit there. As we register these crashes, we have the total sum of maybe, let me use one of 2024, where we registered 25,107 road crashes. When we break it down, we realize that the fatal crashes were 4,179. That is the number of crashes. So the number of fatal crashes. So when we look at the number of fatalities arising from the fatal crashes, there were 5,144 people we lost last year alone. So there are instances where the number of crashes seems to be less, but then the number of fatalities are high. For example, you might have a bus carrying about 60 passengers. it is involved in a crash, say maybe it overturns and then you lose about 20 people. So it is a single fatal crash, but with 20 fatalities. So I hope we move along together when I'm using those terms. Then the number of serious road crashes increased from 12,487 in 2023 to 13,134 in 2024. So serious crashes, like I explained earlier, is where we are having people get injuries as a result of collisions. When we go further, we also categorize fatalities by road user category. This is where we look at our statistics, show us who is the most vulnerable or which people are dying the most. Of the 5 of the fatal road crashes registered last year, 82%, we had 228 drivers die. We lost 228 drivers, 1,720 motorcyclists died, 676 passengers on motorcycles died, pedestrians were 1,666, vehicle occupants were 823, and then the pedecyclists were 138. So when you look at that breakdown, no one is safe. From the passengers, riders, drivers, occupants, pedestrians, even those who are pedecyclists who are using bicycles, we're registering big numbers along that line. When you look at road crash victims by gender, 82% of the people who lost their lives in 2024 were male, and 18% were female. And more than half of the people who died were below the age of 35. The implication of that is that most households in this country are headed by men. So if we are having 82% of the 5,144 being male and they are dying, that means homes are being left without people to caretake. And as a result, we find children drop out of school, the income of the family in one way or another goes down or is even not there because the breadwinner has gone. And that's why you see maybe things like crime increasing. There's a basis for some of these crime coming up in the country and on the increase. When children don't go to school, they'll have to look for ways of surviving. In some households, when the breadwinner is gone, the mother leaves and maybe leaves the children on their own. That is now the effect from traffic it goes into. Now it escalates into other bigger problems. And when we look at the number of people who got injuries, 73% of the victims involved in serious road crashes were male. That also has been interpreted in a way that if we use the example of a boda rider, if he gets involved in a road crash, usually they get fractures, a limb or both are amputated. Meaning if he has a wife at home, if the wife has been working, she will have to leave her job to go and nurse the husband. So the husband who has been the breadwinner, if the wife has been supplementing and she has to also abandon her job in order to caretake her husband in hospital, who is going to be there for a minimum of, say, 9 months, that means there will be no earning in that homestead and creates a big kind of dependency. You find that they have to rely on relatives or friends for survival, and those people may not be able to take them on for a long time, and because of the implications of that kind of dependency relationship that arises from that. So road crashes does not stop at someone being injured. It goes further into other social factors. When we look at the main causes of these crashes, it is globally accepted that 80% of these road crashes are due to human error. And according to the 2024 annual crime report from police, the main causes of these crashes was careless overtaking, which accounted to 5,657 crashes, and speeding, which accounted to 5,500 crashes. These two combined accounts for 44.5% of the crashes that were registered last year. Just only two, when you look at just two causes. Other causes that we looked at in our report, we looked at dangerous vehicle condition, careless pedestrians who cross at points of their convenience, even where their pedestrian crossing is painted, then violation of speed direction. Under speed management, studies show that the most dangerous of the key factors still in road safety is speed. The WHO conducted a study where it revealed that the speed at which a vehicle travels directly influences the risk of a crash. And if the crash happens, it also leads to the crash is likely to be severe, and the likelihood of death resulting from that crash is also high. In that study still, it was noted that for every 1% increase in average speed, it produces a 4% increase in fatal crash risk and a 3% increase in the serious crash risk. That is the effect of speed. And similarly, a 5% reduction in average speed can reduce the number of fatalities by 30%. That takes me to the reason as to why the ministry, together with other stakeholders, came up with the Traffic and Road Safety Prescription of Speed Limits Regulations of 2024. It is against the background of those statistics that I've shared. The aim was to improve driver behavior among road users and to develop a safety culture which protects the most vulnerable road users, especially the pedestrians and passengers that do not have control of the vehicle. The key provisions in these regulations is the prescribed speed limits for the different categories of roads. There was a breakdown of the speed limit requirements depending on the type of motor vehicle you're using and the type of road that you're using. And the 30 kilometer per hour limit was reached out for traffic movement in areas of human traffic. The reason why the 30 kilometer per hour speed limit was arrived at is that we are having a high number of both human and vehicle interaction in mostly built-up areas in the cities, along the roads, especially urban areas. And we had to come up with a way of regulating that interaction by lowering the speed limit to 30. Under the same regulations in Schedule 2, it provides for the different speed limit in urban areas, trading centers, and other built-up areas for different types of vehicles. For example, along in the expressway, the maximum speed limit is 100 kilometers per hour, but that excludes what we call engineering plants and heavy goods vehicles. Engineering plants include vehicles like cranes, excavators, because you cannot have them move at 100 kilometers per hour. Their reaction time is narrowed, and we shall register a fatality. So there was that kind of separation or demarcation depending on the type of vehicle you're using and the area. For urban areas, for highways traversing urban areas, let me use an example of the road I'm more familiar with, Masaka Road. let's say at Lyantonde, because it is a highway traversing an urban area. The speed limit there is 50 kilometers per hour. In areas where there are schools, the school zones, churches, markets, it is 30 kilometers per hour. Then we have community access roads. When you, let's say, for example, if you have a main road and then you have a road that goes off the main road, maybe to maybe to churches, to homes, it is 30 kilometers per hour. Then in Schedule 3, we also have the maximum speed limit for roads in rural areas. We have seen also a high number of vehicle interaction in rural areas. We have a lot of borders. People are also been able to buy motor vehicles, and still that interaction with the other road users is also regulated under the speed limit regulations. Maybe I'll share them with you later. The same regulation also creates offenses for exceeding driving above the prescribed speed limit. If you drive above the prescribed speed limit by 1 kilometer to 30 kilometers per hour, for instance, if you're driving in an area that has a speed limit of 50 kilometers per hour and you're driving at 52, the penalty is 200,000. If you're driving at 50, let's say 58, still it is 200,000. But when you exceed the prescribed speed limit by 30 kilometers per hour and more, the penalty is 600,000. So if you're driving at 80 kilometers per hour in an area whose speed is 50 kilometers per hour, you'll be penalized by a ticket of 600,000. Now that takes us to the express penalty scheme regulations of 2024, where it also it lays out the time frame within which to pay that ticket. So if you previously before the amendment, a driver was given 28 days to pay the fine. But in the new regulations, a driver is given 72 hours, a driver or the owner of the motor vehicle, because the notification goes to the registered owner of the motor vehicle. You get a notification via SMS and email. The details you used when you're purchasing, and that previously it was under Ministry of, Uganda Revenue Authority, but now it is under Ministry of Works, so they have all those details. So if you sold the vehicle and you did not effect a transfer, the notification will come to you, because in the records, it reflects that you're still the owner. So that, so previously it was to be paid in 28 days, but now the payment has to be done before 72 hours elapse. So if the 72 hours elapse, what happens? A 50% surcharge is added on to the penalty. So if you have a penalty ticket of 600,000, so you add 300,000 to make it 900,000. And for every violation that is committed with the different cameras we have in the city and in other areas that are covering the country, for every violation, it comes with a different penalty. So if you're going to move from here to, say, Ginger, and you are, for each camera that is on that road is getting you driving above the prescribed speed limit, it will be a different ticket. So you can accumulate tickets, penalty tickets, even of about 2 million in just a single journey. That is basically for the two regulations that have been have attracted attention in the media, and probably rightly so, because we make the laws for the people, and when people protest, we are obliged to listen. And as of last night, these two regulations, especially the EPS regulation, was suspended pending review of some of the issues that were raised. And we are still waiting for communication from the Minister of Works and Transport. I was also asked to briefly talk about the recent amendments, where we have that Traffic and Road Safety Wearing of Seatbelt Regulations of 2023. It requires a driver of a motor vehicle to ensure that a child who is below 5 years of age is seated in the back seat of the vehicle. Yes, I'm also a mother, and we have a tendency where we have those baby seats. You put them in the co-driver's seat with the baby facing the seat, and then you strap the baby. It is very dangerous. We have registered incidents where those babies actually fly out of those vehicles when there's a collision. So the law now requires that a child below 5 years of age is seated in the back seat, and you're supposed to use appropriate child restraints suitable for that child. The driver is also further required to ensure that a child who is above 5 years of age but below 12 years of age sits in the back seat of a motor vehicle and is also strapped with a seat belt. It is an offense if you contravene that provision, where you're liable on conviction to a fine not exceeding 30 currency points, or imprisonment, or both. Then we have the Traffic and Road Safety Motorcycles and Motorized Tricycles Amendment Regulation. It requires that in addition to wearing a safety helmet, it is supposed to be fastened. We've been registering incidents where most people use the motorcycles. They just place the helmet on the head when they see traffic officers in the vicinity. So what happens when a collision happens? The helmet flies off, then there's that direct impact of the head and the tarmac or the ground, and then someone ends up dying, yet could have been protected. So in addition to placing it on the head, you're supposed to fasten it under the new regulations. Then we have the Traffic and Road Safety Post-Crash Emergency Care Regulations. These were mainly put in place to protect the first responders. There used to be instances where first responders would rush to a scene of a crash, and when they would get there, somehow things would be twisted, and then they are accused of knowing what could have happened or participated in what actually happened. So these regulations protect first responders. Then we have the Traffic and Road Safety Demerit Point System Regulations of 2023. Under these regulations, where a driver is convicted and there's an order from court that a certain number of points be deducted from the driving license, they will be deducted under the demerit point system. Then we have the Traffic and Road Safety Digital Network Regulations, the one that regulates transporters like Uber, and then I've heard of Faras. It regulates their work in this country. Then we have the Traffic and Road Safety Prescribed Alcohol Limit Regulations still of 2023. Thank you very much.
Thank you so much, Superintendent of Police, Ken Taro. We thank you for breaking down what has been going on in the media for the past 2 days. We do not take your presence for granted. Ladies and gentlemen, right now, we have our second speaker, Dr. Isaac Luvogo. He is joining us online from Nairobi. Dr. Isaac Christopher Luvogo holds an LLB, Magnum Cum Laude, LLM Summa Cum Laude, and a Doctor of Laws. He is an author of about 20 law books, most of which are groundbreaking in jurisprudence. He is the founder of the Sui Generis Law App, a one-stop state-of-the-art e-library for everything you ever need to know. Dr. Lubogo.
Yeah, can you hear me for avoidance of doubt? Can you hear me? Can I get some feedback, please? I just need feedback for purposes of verification.
Yes, doctor, we can hear you. Please go ahead.
Okay, thank you very much. I am, first of all, I thank you for giving me the opportunity to have this wonderful discussion in light of a very interesting discussion for purpose of what is happening in the country today. I thank the members of the Uganda Law Society, particularly the ones who belong to the revolution in terms of the changes that have been brought about by my esteemed friend and namesake, President Isaac Kimaze Semakade. So I would like to thank you so much for giving me this opportunity to share a few things. I will go through a number of issues. Particularly, I want to start with discussing what I would call the 360 angle, 360 view angle, vintage view in terms of this particular law that has taken Uganda by storm in light of the so-called backlash, if you want to call them so. So I will argue in terms of the operationalizing of these laws, and then I'll argue in terms of the social, political, and economic aspect. And then I'll argue in terms of the moral question, because this was evidently brought out, whether or not it will reduce accidents, or to use my esteemed friend Kentaro's word, crashes. And then I'll argue in light of Uganda's readiness for machine-based traffic enforcement in terms of what they call technological readiness. And then I'll also argue in terms of zoning, because again, this was brought out evidently by the Honorable Minister in terms of zoning in high-risk areas, places like Kampala, in terms of an analysis of its tenability. And then I'll argue in terms of these traffic failed laws. The esteemed sister was talking about certain aspects in terms of seatbelt laws, and then I'll argue in terms of those other laws that have collapsed. Why are we thinking that this one will not collapse at a certain time T? And then I'll argue in terms of the each question of appeals. What happens in light of appeals? Where do we appeal in such a law? Are there substantive provisions in terms of address? And then I'll argue in terms of what they call the unaddressed issues that I would have imagined that the minister or whoever had come up with this law would have taken coincident or particular redress in terms of addressing what they call the blind spots in terms of the ones that I'm going to shed light on. I will not argue corruption, because I know corruption is heavily captured in terms of the media and what the media has said in terms of who is walking out with what percentage and who is benefiting, who is defending the matter in court. Those ones, I'm sure, is public knowledge now. So let us go back in terms of the legal analysis. We shall understand that the origin in terms of the implementation of the Ministry of Works and Transport happened way back in in April, particularly in the Ministry of Works and Transport, in partnership with obviously the Uganda Police Force, operationalized the automated electronic penalty system under the umbrella of Intelligent Transport Monitoring System. And basically, the argument here is that the system relies on what they call AI-enabled cameras and automatic number plates in terms of what they call recognition, call it the ANPR, to detect and record traffic violations in terms of also triggering immediate issuance of electronic fines, for example, without prior human adjudication or notice. I've traveled a little bit, so I am cognizant and aware of how this system works in a country like Germany, for example, because I was driving and I could see how that occasioned on us in terms of how they'll play it out. Let's argue in terms of this aspect of designation, for example, as an enforcement. Whereas it was introduced with, without any direct amendment to the parent legislation, which is CAP 361, and particularly without parliamentary approval. It was rolled out through ministerial discretion, raising immediate questions of legal foundation, procedural legitimacy, and also constitutional compliance. When you argue in terms of the legal foundation, in terms of these operational roles, and in terms of the delegated authority, we could argue in terms of the primary legislation, the Traffic and Road Safety Act, obviously, CAP 361, the enabling legal framework in terms of particularly Section 165, which provides for the express penalty schemes and empowers the minister, obviously, to make these regulations for purposes of what? Implementation. I'm going to move a bit fast because I know that I have, short time, and I want to do as much justice as possible. So the use of AI, obviously, in terms of automated systems, enforces penalties, no doubt, and imposes fines without prior engagement on the assumption of guilt without trial, for example. Obviously, this introduces a doctrinal inconsistency in terms of what they call subordinate legislation, as far as these regulations are concerned, that cannot fully, introduce a substantive regime which is not contemplated in the Principal Act. Therefore, the use of the EPSAuto under CAP 361 is in its current unamended form, which violates the doctrine of, ultra vires. Secondly, in terms of the legislation of the EPS as a regulation, as amended in 2024, the Traffic and Road, Safety Express Penalty Scheme of, for road traffic offenders, originally enacted in 2004 and amended in 2024, are cited as the basis of the ES, auto implementation. However, these regulations, while updated, remain structurally inadequate to support a digital and AI-based enforcement regime. And obviously, when you're arguing in terms of that, you look at the key provisions that operationalize this particular aspect. Look at Regulation 6. I'm just trying to go through, but I will share a detailed dossier, which I think will be relevant to the ministry, but also to the members of the Law Society. In terms of Regulation 6, Regulation 7, obviously Regulation 7 imposes a 50% surcharge, after 72 hours, and then the aspect of impounding vehicles, blocking of driver's license, and then issuance of court summons and travel restrictions on foreign registered vehicles, for example. Now, critically, these regulations make no provisions of a hearing, for example, in terms of objection processes or even independent appeals before any enforcement begins. And this constitutes administrative punishment regime devoid of constitutional safeguards. So in terms of constitutional deficiencies and doctrinal violations, you want to argue in terms of Article 28, which talks about a right to fair hearing. EPS auto violates Article 28, Article 1 of the Constitution, which guarantees that every person charged with an offense is entitled to fair, speedy, and public hearing before an independent impartial court. I'll argue that later in terms of the EPSAuto. But also, it also imposes fines without trial. It provides no opportunity, for example, for the accused to be heard, and it delegates adjudicative functions to police officers who are both enforcement agents and alleged reviewers of the objections. And that is something you must understand again. So this constitutes a reversal of the constitutional right to a fair hearing and varies the fundamental principle of ud autem partem. Let the other side be heard. Okay? Look at Article 44C, the aspect of non-derogable rights of fair hearing. The right for fair hearing is non-derogable. So EPS or EPS auto sidesteps these judicial processes entirely, instead of empowering administrative practices to issue and enforce penalties without legal processes. Look at Article 42, also in terms of the right to administrative redress. Look at the so-called EPS desk at the police, where the stations are. They are not independent. They are not established by law. They are staffed by officers with no legal training and even tribunal powers. There is no statutory framework, for example, laying out procedures in terms of timeline, in terms of evidentiality, in terms of rights. Thus, the EPS auto appeals framework does not even satisfy Article 42 in terms of the protections. When you argue Article 21, for example, the right to equality in terms of freedom from discrimination is another aspect, and these are things that you want to talk about when you're looking at the entire thing. So this constitutes indirect discrimination in terms of breaches by virtue of Article 21, Article 1 and 2. When you look at Article 121, justice without regard to technicalities, the constitutional mandates that justice shall actually be done to all regardless of status and must be subjective, not merely technical. So the EPSAuto imposes fixed financial penalties irrespective of income. It denies appeals to dignity or financially excluded individuals. It operates on strict liability, even in cases mistaken identity, for example, even technical error. Think about that. So the aspect of the uniformity of penalties without context or discretion offends the principle of substantive justice as enshrined under Article 126 2A. That is extremely important for you to understand. Now, I know there's case law, so I'm not going to argue case law, but I want to argue another aspect in terms of, in the interest of the discussion we're having today, in terms of the aspect of socio-economic and political constraints in terms of the EPSAuto in Uganda. When you argue in terms of socio-economic constraints, you could argue in terms of what they call the disproportionate impact on the poor and the informal sector. Uganda's economy, for example, is predominantly informal, with an over 80% of the working population engaged in informal activities, including border riders, who, by the way, are on record to have rescued the Honorable Minister at a bad time, we all know, in terms of tax operators, in terms of street vendors, in terms of small-scale farmers. These individuals often survive on less than 20,000 shillings a day.
Recording stopped.
So, now, if you're talking about EPS as auto, it imposes fines ranging from 10,000 to 1 million, which are unaffordable to most informal workers, not graduated in terms of based on income levels, not even on a sliding scale, and unaccompanied by grace periods or hardship waivers, for example. A practical example is, for example, a border rider, say in Uganda, Oluwero, is fined about 600,000 for speeding on a school zone. Yes, without legal knowledge, internet access, means of appeal, he may have a motorcycle impounded and instantly destroy the livelihood of, or punishes the household entirely, just on the basic of that aspect. Talk about the fact that many of them don't even have smartphones, and you're talking about generated, responses that have to be imputed on your phones, and then, the message comes in. In Europe, it's done the other way, because in Europe, they have what they call residences, a postal address where it ties you down to the place where you actually are. You don't even have to question anywhere. You just simply say, I stay in this block, in this area, and they'll find you there.
Progress.
And they'll find you there at that material time. In Uganda, it's another question. Identity is a big question. Even our so-called identity cards are not generated or automated related to where we stay, for example, in terms of a GPRS system finding you squarely. So we're talking about a system that is, yes, thought about as a good idea, but impracticable in terms of Ugandan aspect. Talk about digital exclusion in terms of technological illiteracy, for example. EPSAuto is digitally enforced as a system relying on SMS notices, electronic payments, and even AI surveillance, and even online patrols. Yet digital penetration in Uganda remains uneven, especially in these rural areas. And this is a big point, my friends, that we need to think about. Then the infrastructure irony and the state failure itself, in terms of the EPSAuto demands strict compliance with road traffic regulations, yet many roads are actually unpaved, pitholed, for example, and even unmarked. Talk about speed limit signage in terms of inadequate or non-existent in some areas. Street lighting is absent in many rural and even pre-urban areas. I know you're going to argue in terms of zoning, which I made as a particular subchapter, and I'm going to talk about that evidently for purposes of demystifying some of those components that you may have in mind. Then if you're talking about political constraints in terms of persecution of state extortion and even digital tyranny, Ugandans have historically mistrusted centralized revenue-driven enforcement schemes, especially when transparency is lacking. So EPSAuto is widely viewed, for example, as a state-sponsored crash grab. We have seen that, we have heard about that, as a system meant to extract revenue, not to promote safety, and even aspect of even foreign-controlled initiative due to Russian contractors involved. Those are things that make you have a sleepless night when you begin to argue in terms of the socio-economic aspect. I would like to argue now in terms of the moral question, which is something that I had the Honorable Minister evidently talk about, the moral question. And this is where many of the supporters of this law argue in terms of the moral question. Will, for example, the EPSAuto reduce road accident or road crashes in Uganda? It's a presumed, moral purpose in terms of the EPSAuto. On face value, the moral justification for EPS is, defensible. Uganda loses thousands of lives annually to road crashes, and traffic enforcement, has historically been riddled with bribery, selective prosecution, and even manual inefficiencies. So you could argue that according to Uganda Police Annual Crime and Traffic Report of 2023, for example, over 20,000 plus crashes occurred in 2023. About 5,000 plus people died, and an increase of about 80.8 since 2014. Yeah? So 70% of the deaths involved vulnerable road users, pedestrian, border riders, and cyclists. So in light of these grim statistics, a moral argument can be argued in terms of EPSAuto. That is, automation eliminates corruption, block roads in terms of bribe phone, human officers, and stuff like that. AA surveillance detects violation in terms of what? Accurately or even inconsistently. Instant fines will deter reckless behavior, especially over speeding and traffic light violation. So the argument is that the moral goal is rooted in saving lives, enhancing order, and restoring public safety. It has no residual aspect in terms of understanding, and you can be dismissed lightly. Why? Because the counterweight deeper causes of road death in Uganda are a little bit more than that. Morality in public policy is not determined solely by intent, but by real-world effectiveness and fairness of implementation. And here lies this contradiction. Number one, the EPS focuses on punishing individual drivers for, infractions, but ignores the broader ecosystem of death and dysfunction on Uganda's roads, particularly. For example, poor road infrastructure, the state's moral dereliction in terms of that. Uganda's roads, especially outside urban centers, remain not even urban, by the way, non-urban, for example, but even the major centers. Walk me through Kampala. I'll show you a pothole every after a kilometer or so. Pothole-driven aspects in terms of forcing dangerous lane switches, unmarked, speeding, for example, limit compliance. These become arbitrary. And then poor lit streets, especially at night, eroded edges, particularly during rainy seasons. So you could argue that the Uganda National Roads Authority admitted in its 2022-2023 infrastructure performance report that over 60% of Uganda roads are poor and in a fairly bad condition, and only 17% of the total national roadwork was actually paved. Think about that. So the moral paradox: how can the state criminalize drivers for poor navigation when it has not even fulfilled its own legal duty to actually provide safe, passable roads? That is something you want to think about. Then there's aspect of lack of emergency services and traffic control capacity, for example. Uganda's road facilities are not only caused by accidents, but they delays in response and even inadequate post-crash care. The World Health Organization, for example, in terms of the global status on report on road safety in 2018, noted that Uganda has less than one functional ambulance per 100,000 people, and the emergency response time averages between 45 to 90 minutes, often on longer, even in rural areas. So while the EPSAuto may actually record an overspeeding incident, it cannot save a bleeding child hit by reckless border on a dark, unlit road, for example, in Arua, or even in real moral deficit lies not in poor driving alone, but in the lack of a system that can actually respond, rescue, and even rehabilitate. I would like to also argue in terms of another aspect, in terms of what I would argue in terms of the aspect of whether or not Uganda is actually ready for this so-called machine-based traffic enforcement, in terms of technological readiness, in terms of legal maturity and institutional capacity. The promise of smart enforcement vision versus context, for example. At a glance, machine-based enforcement, automated number plate recognition, for example, red light cameras, AI speed detection, represent technological modernity. We all love to be there. In countries, for example, like UK or Germany, for example, and Singapore, such systems reduce bribery, ensure consistency, and generate real-time data for policy action. Now, the EPSAuto, as adopted by Uganda, seeks to replicate this model. Cameras monitor these so-called intersections and speed zones, no doubt. AI, for example, classifies offenses and triggers automated fines. SMS is used to notify violators instantly. Now, whether that is wonderful, the intended logic is something compelling. Human corruption, unfortunately, is replaced by these machines in terms of impartiality. But a critical question emerges: does Uganda possess the fundamental architecture to implement such a regime justly, equitably, and even sustainably? Yeah. So in addressing such, you want to look at the 4 pillars of readiness, which Uganda ought to look at. Number one, the aspect of legal and institutional framework, underdeveloped for AI governance, for example. Uganda's legal system lacks a coherent framework to govern what they call AI machine learning or algorithmic decision-making, especially in public enforcement. Now, the key gaps would ensure, in terms of no AI Governance Act, for example, Uganda has no specific law in terms of regulating the use of AI in public administration, especially concerning transparency, even algorithmic biases, or even appeal mechanisms. Yeah, and if you argue in terms of what? Of the data protection, yes, you could argue and say, wait a minute, we have the Data Protection Act, but other than these things evidently being in books, it's another cause for discussion. Now, let me take you through what I call the zoning in terms of the zoning, because this is another aspect that has been heavily relied on by the proponents of this aspect. In terms of zoning, EPS, for example, in terms of what they call high-risk areas. In Kampala, for example, can we analyze its tenability and possible constraints? When you argue, in theory, zoning expresses the traffic penalties in terms of applying, EPS auto in specifically congested, accident-prone areas or even pedestrian-heavy zones, yes? And it is a reasonable and even potentially life-saving strategy. It recognizes that not all roads are equally risky, and nor should all violations attract the same degree of scrutiny in terms of penalty. But this strategy mirrors an international best practice in terms of urban mobility and even what they call smart engagement. And this is something you need to look at in terms of that, in terms of understanding those aspects. So before you argue cameras or AI, how do we have them concentrated in known black spots, for example, in school zone or in junction markets, for example? Are these enforcements, for example, graduated by zones with similar penalties where pedestrian safety is actually most threatened? In Uganda, and particularly Kampala, this would suggest prioritizing areas, for example, around Clock Tower or Wandegea or Chiseka Markets or Bench-Wanka Street, such aspects. So these are aspects that we need to look at whether or not we have all these things played out in terms of the discussion. Now, let me take you through what I would like to call whether or not we will succeed in terms of understanding or underscoring some of these aspects in terms of how whether or not Uganda can play out in terms of a succession story. We have had instances, ladies and gentlemen, where the law, for example, has not played out in terms of seatbelts, for example, in terms of speed governance. What happened to the big-headed speed governors that were operating in this country at one upon a time? Where every individual was actually required to put in speed governors, and lo and behold, we never saw it happen, So these are things that we may have the intentions are right, but have we had consensus? Have we had discussions in light of all stakeholders? We believe that the law is good, and we believe that the intentions are good, but is Uganda ready, given its socio-economic and political terrain, to accommodate and understand that AI, which is even a big struggle for people to comprehend today? And the honorable, distinguished lady, Kentaro, made a very important point. She said, listen, the aspect of error was arguably reported to be human 80%. If humans are erring in terms of 80%, how about non-humans? Think about that. How about non-humans in terms of cruising crashes and accidents, stuff like that? So we are having a big problem, ladies and gentlemen, in terms of comprehending and understanding some of these things. Then I have an argument in terms of appeals, whether or not we have substantive appeals, even remedies in terms of the law for purposes of appeal. How about those unaddressed blind stops? So I will be able to share with the people that be in terms of the dispensation of some of the things that I would love to cover. But in the interest of time, I want to thank you very much. And I hope I have been of justice, because I'm mindful that other people have, other interesting discussions to make. Thank you, and God bless you.
Thank you, Doctor. Ladies and gentlemen, another round of applause for Doctor. To help us further understand the topic is Senior Advocate Stanley Okecho. He holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal practice from the Law Development Center. He is a partner with JAM Advocates. Before joining the firm, Stanley attained diverse experience in the social justice and human rights field as the program officer in the Strategic Litigation Department at Center for Health, Human Rights and Development. Stanley is well grounded in lobbying and negotiation, and also boasts of a well-documented history in organizational leadership. He has cultivated a specialty in advising clients on dispute resolution, corporate governance, human rights, regulatory compliance, structure and implementation of project finance, as well as a stint on some of landmark public interest cases. Mr. Stanley, welcome.
Thank you so much. I would like to thank the management of the Radical New Bar for this opportunity and to share my insights on a number of issues, also on the digital number plates, more specifically now known through the ITMS or EPS regulations. Firstly, I thank the President of the Radical New Bar, President Isaac Semakadde, for exercising vigilance on the Intelligent Transport Monitoring System, or ITMS, which posed monumental risks, whose harmful effects that the greater public has just realized when the injustice has finally come to their cars and wallets. This scandalous project started actually in the COVID-19 pandemic. At this point, I want to emphasize that there is a link between the ITMS and the EPS, because the ITMS is a technology driving the EPS system. Well, from the onset, it is more evident that this is a predatory system, and its main intention or objective is to raise revenue for those that are really behind it. And I want to state that as early as July actually 2021, President Isaac Semakadde had already started banging the table, because at this point, only few people know that a number of people who can barely go beyond this room had hatched a plan to extract up to $1 billion from Ugandan taxpayers through the non-tax revenue. This system, as you may recall, was launched by the Ministry of Works and that of Security. And I want to state the interventions that we have since done from the time we realized about this predatory system. For example, from the onset, there were about 2 Ugandan companies that were in the business of manufacturing number plates. I think there is GM, Tampeco, I forget the other one. As we speak, those 2 companies are out of business. I think one was sent to operate in Sudan. I understand it might have had people that it employs. Contracts were cancelled, and I believe, as you've seen from the astronomical finds from this system, it's a system that was never intended about the safety of the people, but rather to benefit only a cabal of people, whom we already know, by the way, as early as 2021. We want to start with the first intervention that we took. Number 1, the High Court Civil Division, by around 2021, certified that the matter of stopping the intelligent transport system was very urgent. You may recall at that point, even advocates were considered non-essential, but court certified that miscellaneous cause number 225 of 2021 was very, very urgent. In this case, the applicant is Legal Brains Trust, who duly instructed our firm, GEM Advocates, to file a Human Rights Enforcement Act motion seeking a declaration that the presidential directives cabinet resolutions, advice or approval by the Attorney General, contracts, statutory instruments, or other documents by whatever name called, through which the government of Uganda had purportedly engaged a Russian company called the Joint Stock Company, Global Security, or any other person or authority to execute a program of digital surveillance of all motor vehicles, motorcycles, and other vessels. This can also include boats. In Uganda, that this violated a bundle of rights and protected freedoms. It is important to note that some of these violations are not yet known to the public. For example, the ITMS violates in its present form. I'm also mindful of the sub judice rule. Since this is an ongoing case, I'm only restricted to stating what is already in court. For example, the system violates Article 21.1 on equality of all persons, Article 24, which is on respect for human dignity and protection from inhuman or degrading treatment. For example, under this new system, you may not know, but you will have to be surveyed for 24 hours. There is an infringement or a threatened infringement on the right to privacy, home or property. We've maintained that the government has no business following us around. You can't follow everyone, everywhere. For example, there is a cyber stalking law that prohibits people from being stalked. You can't follow people from the streets everywhere they go. For example, why would you otherwise track persons that have no linkage to crime or terrorism? There are civic rights that are being breached, but most importantly, the government, by engaging the Russian company, created a monopoly. This is not the first time it is happening. Sometime in 2000, when you look at the case of Spedag Interfreight Uganda versus the Attorney General, a certain family linked to the first family created a company which was given rights to have exclusive rights over the port, the purported port in Tororo, and by giving this one company rights, it took companies like Spedag to fight this monopoly. So you may recall that all Ugandan companies that were in the business of manufacturing number plates have since been laid off in favor of a Russian company. I think this case that I've just given highlights the importance of courts in curbing creation of monopolies. And then there are a number of other rights. And then who actually stores this data? You've seen over the past weeks that pictures of cars are being shared. Now, how do you guarantee that, one, this information is stored, and any other person that might otherwise be trading you won't have access to this information? Secondly, there are data protection concerns. We don't know who the data protection officer is in terms of the Russian company. Now, pending determination of this main cause, the human rights enforcement application, we filed a temporary injunction application in July 2021. It took the High Court. You know, the anger of the people has been directed to the wrong people. We, at this point, accuse the judiciary of Uganda. It took the judiciary a total number of 539 days to deliver a simple ruling on an injunction. Had we succeeded with the injunction, perhaps the EPS, which is founded on the ITMS system, wouldn't have seen the light of the day. Upon receiving this ruling, which obviously dismissed the application for a temporary injunction, we then applied to the Court of Appeal and successfully had our case fixed before a single justice of the Court of Appeal. I don't know if we're lucky or unlucky, but we landed on the Honorable Justice Oscar Chihika, who, unlike the initial judge who didn't find any grounds of a temporary injunction, the lawyers know you must have a prima facie case, you must have a status quo to preserve balance of convenience. The judge agreed with us that at least we satisfied close to 3 grounds, but only didn't satisfy the one of balance of convenience, because the government was then in a rush to implement this program. So we've so far accused one entity or one institution, which is the judiciary. Now, pending the second ruling now of the Court of Appeal, initially this program had skipped even Parliament. But now they worked backwards and dealt with a number of MPs who sat in a committee and green-lighted approval of this project. It only took a few reasonable MPs who saw what you've been able to see in the past days. For example, concerning the sharing of this money, and our government negotiated a very bad deal. More money goes back to the Russian company with over 80%. You can question whether all this money is indeed going to the Russian company or it has a number of other beneficiaries that are not listed or known anywhere. We then take issue with the exercise of the functions of Parliament that didn't exercise caution in trying to stop a project which would ultimately affect the general public. So this pseudo-parliamentary approval only created harm. We've also been made to understand that the major reason why this program is being fronted is because of crime. Incidentally, to those of you who pay close attention, at the time they were launching this program, they were murdering women in Entebbe. None of these suspected murders were using cars. So you can't get the empirical evidence of stopping crime and this system that they greatly want to impose on the people. And I think from that, everything about the Russian company, its financial capacity, its financial model, pending the temporary injunction, we also filed an application for discovery. For example, everything surrounding this project has been a mystery, from the contract that government signed to the feasibility model to the sharing agreement. All these agreements have been kept from the public. I want to remind you and emphasize that every Ugandan has a right to participate in the affairs of government, whether directly or through their individual representatives. Secondly, Uganda is a member of different blocs in the region. For example, the EOC, EAC, and also the COMESA. Now, if the intention was to stop crime with cars used within Uganda, what then happens to vehicles that have free access to exit and enter Uganda that are coming from Kenya or from the COMESA? Why are you not? It would have been more prudent that this is a project that goes across maybe the entire EAC block or the COMESA. And then we have a number of concerns. Number one, as we speak, the last time we appeared before the Court of Appeal was in 2023. We had to make a reference where you're dissatisfied with the decision of a single justice. You then apply to a full panel of 3 justices to review any decision of a single justice for over 3 years from the time we filed the motion and close now to 2 years. The Court of Appeal has never found the urgency to fix that reference for hearing. We note with concern then that the judges have eroded the judiciary as a forum for checks and balances. It was at this time that the judiciary ought to have done what Parliament didn't see and what the executive is vehemently pushing down to execute. And then this will leave Ugandans with no any other option, save for maybe civil disobedience. We have seen that as of yesterday, they have again attempted to hoodwink Ugandans by suspending the EPS system without suspending the ITMS, because the EPS system, when you look at regulation 3.2 of the regulations, it clearly states that it is being implemented on the basis of the ITMS system. So without stopping or dropping the ITMS system, by suspending this EPS system that is clearly hoodwinking Ugandans, we emphasize and urge all that are involved to completely drop this system. There are other alternative systems which are less intrusive. For example, Professor Isaac mentioned something to do with the automatic number plate reader system. All you need is a working camera and then maybe other technology which can detect the movement of cars, and you issue receipts. If you find it more prudent, why then do you have to place a gadget on a motor vehicle to track a car without limit? And then I want to briefly talk about the regulations. One, the regulations are in themselves illegal from the onset because they are founded on an illegal and illegitimate system which is being challenged in courts. A number of people have already mentioned, but to mention but a few, the system doesn't respect the due process. Back then, Nafande has mentioned that the person had to pay these fines within a period of 28 days. Why the rush now? So for the explanation that maybe money has to be collected and shared, that you have to force someone to pay the penalty within 3 days. I think in conclusion, we urge the following stakeholders to act accordingly. We call upon the judiciary to expeditiously file, rather fix the reference to the entire court, to the full panel for hearing. We urge government to immediately drop the ITMS system, suspending the EPS system, whose empirical evidence is not even existing, is not sufficient. And we call upon activists to always show up but not show off. This is an issue that has been around this country for close to 4 years, from 2021. And to lawyers to be more vigilant. It is shocking that some of the lawyers or some of us only saw the regulations after they had started implementing them. We only start to comment as ordinary citizens. We call upon everyone to be most alert in terms of fighting such policies. I thank you.
Thank you so much, Senior Advocate. Our three speakers this afternoon have shed more light on the topic road rage, frequently asked questions about Uganda's automated electronic penalty system under the Intelligent Transport Monitoring System, and we thank them. A round of applause for them as we now enter into the Q&A session. Our first question goes to SP Kentaro. It comes from Namudu, Caroline. There is propaganda online where people are saying that government cars are exempted from EPS penalties. Is this true? Is it justifiable? If we must reduce speeding and road accidents, the law must be observed for all. We have a second question from Tito Kevin. Thank you, Mr. Okecho, for the litigation done to hold the state accountable. My concern is about the recommendation to remove the ITMS system. The system has some advantages, especially in curbing violence. What other alternatives can the government use? Thank you.
Other two questions, right? Thank you very much. Government vehicles are not exempted from being fined under the new EPS regulations.
Thank you so much. One, it is important to note that the system in its present form aims at tracking every vehicle owner. This includes ministers, judges, private individuals, whereas they have painted it as a very good system. From the onset, this system prioritizes more of generating government revenue compared to achieving its intended objectives. For example, I've argued before that the first thing to do is to do the simple things right. As of today, and you may also have means and less intrusive, less predatory that the government can use. You don't need to track people 24 hours. For example, you can't guarantee that this system cannot be abused by spouses to track or to find out the whereabouts of their spouses, political opponents, robbers, or people engaged in high crime. So there are other less intrusive means that the government can put in place. The ITMS in its present form was predatory from the onset. You're yet to see its more shocking revelations. As a country, we are embarrassed. You cannot have such a system that is preying on Ugandans for the benefit of a few individuals that are pushing it and making sure it is implemented. So I maintain it has to be dropped. There are other less intrusive means and systems.
We have a question from Sam in-house.
Good afternoon, everyone. Before Sam, I have just one quick question. For me, what I'm really trying to understand is what's the objective of the regulation of carrying physical logbooks? What is it really trying to achieve? I really don't understand, so just some more light on that.
All protocol observed. Good afternoon to our beloved Afande in the house. Yesterday, while I was watching the news, the Minister of Works and Transport, General Katumba Wamala, said that yes, these government vehicles are not exempted of the penalties. But in his words, he added saying that in the event that this penalty is given to a government car, the bill or the fee be given to the permanent secretary. And in the event that the permanent secretary does not have the money, it will be forwarded to the driver of the car. So I wonder, is it in order for a government worker to break the law and we, the taxpayers, pay the penalty to pay for the driver the fees? So you will help me answer that. You spoke about children not sitting in the co-driver's seat. I also do wonder and would love to ask that if a child is seated with an adult, say I am the adult in the co-driver's seat and I'm carrying this young child, is it okay for me to sit with that child if we are wearing or sharing the same seat belt? Then also, on the matter of the EPS system, I have a reliable source that tells me of an issue concerning double number plates. Online, there are cases where someone is filed the penalty, however, this is a double number plate and that person's car is different. However, they share the number plate. How does the police, or how is the police planning to deal with the issue of double number plates such that the penalties go to the right people? And lastly, as a concerned citizen, I realize that yes, the government is doing us well. They are serving and doing their part. However, I noticed that even many of our roads in Kampala are not marked or labeled well. I see traffic officers hiding in corners, ready to curb those that are using one-way roads. However, there are no signs. Yes, as you are collecting our money, is there something you can do about this to mark roads properly and make it effective for drivers to know what to do for those that know the signs? Thank you so much.
Good afternoon, everyone. My question, I am Marunga Samantha. My question is for the SP. So, what criteria did you come up with to determine the reduction of the time to pay the fine from 28 days to 72 hours? Don't you think this is a strain for us, the ordinary citizens? And what do you think people are going to get, let's say 600,000 within what? Within 72 hours, yet, on average, most Ugandans earn less than that 600,000 that you're fining them. Thank you.
Good afternoon, everyone. Kiza Oscar is my name. I want to give a very quick rejoinder to what my colleague Stanley stated, that we, the lawyers, are rushing for the regulations today. He was my president at the center. What happened is, what was gazetted was only the heading of the regulation. The regulation itself is not in the gazette. So nobody knows what Uganda police was implementing. The minister only gazetted the heading of the regulation, not the details, not the rules therein. So one, police is actually perpetrating an illegality on us. I have also tried to look for the regulations. what is being circulated is, I don't know, a copy gotten from where. So nobody knows what these regulations are. We only have the heading or the title published in the Gazette. So please, none of us knows what these regulations are. The copy is being moved online. I don't know where they're coming from, but it is not law as far as those of us who, labored to look for the Gazette did. Thank you.
I request that we answer those, please.
Thank you very much for the questions raised. I'd like to bundle up some of the questions that were raised. For example, someone asked about payment of EPS as a result of violation of the traffic laws by government vehicles, and why should the taxpayers pay for that. Then there was an issue about the road signs. Then someone also asked about the basis of the figures under the EPS regulations. I'd like to clarify that in as much as Directorate of Traffic and Road Safety works hand in hand with Ministry of Works, they are clear cut. We have different roles that we play. So I'm not in position to speak for Ministry of Works, because they are the ones who come up with policy. For us, we are enforcers. Maybe you can go through different forums and maybe raise the questions there. I think you'll get your answers, but I'm not in position to speak for other government agencies. Yes, still about the issues of road signs, like I said, that is still with Ministry of Works. The basis of the figures, still that is Ministry of Works. They're the ones who come up with the policies that we enforce. On the issue of strapping a child in a co-driver's seat, an adult with an infant, and then they are both strapped in the same seat, the regulations look at safety. If I'm to pass that question to you, do you think that will be safe for you and the child to be seated in the same seat and you're both strapped with one seat belt? If we are promoting safety? Your answer is as good as mine. Thank you.
Any more questions? We've come to the end of our first segment, and I thank you all for actively listening and participating. We will now right away move to our second segment, and that is the civil and military separation of powers, a critical examination of the UPDF Amendment Bill 2025. Earlier this year, in January 25, the Supreme Court delivered a landmark decision in Attorney General versus Kavaziguruka, holding that the trial of civilians before military courts is unconstitutional. On 13th May 2025, the UPDF Amendment Bill 2025 was tabled before Parliament by the Minister of Defense and Veteran Affairs, Honorable Jacob Oboth, and within just a few days, amidst limited discussion, minimal stakeholder engagement, and minimal time for public inquiry, the bill was passed. Shockingly, the bill still includes provisions allowing for the trial of civilians in military courts, directly contradicting the Supreme Court judgment. At one of our Rnblive sessions held on 6th March 2025, we hosted our legal aid clinic in Moroto, who brought to us the relatives and families of the Karachunas in Karamoja. They shared their ordeal about how their family members were arrested and have been held in prisons, sometimes without even appearing in court. They came to the legal aid office in Moroto seeking for help, wondering whether the files of their people will be transferred to civilian courts. Beyond the issue of civilian trials, the bill also contained some provisions that caused public concern, such as designated military attire, where civilians could be unfairly implicated. Today, we are joined by distinguished speakers and experts who will help us unpack the full implications of this bill and guide us on the way forward. Our first speaker is Senior Advocate Caleb Alaka. He holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal practice from the Law Development Center. He holds an LLM from the University of London, specializing in commercial and corporate laws, international investment law, international economic law, among others. He is the managing partner at Alaka & Co. Advocates and is one of the lawyers that represented Michael Kabaziguruka in the landmark judgment where the Supreme Court ordered that trial of civilians before court-martial must cease immediately and all files be transferred to the ordinary courts with jurisdiction. Councillor, you're welcome.
Good afternoon, ladies and gentlemen. Sorry for coming late. ULS, thanks so much for keeping the fire burning. Thanks also to Comrade Semakade. Yeah, here we are. You know, in 1948, there was an aerospace engineer called Murphy Edward, and he came up with an idea called Murphy's Law. I think most of you have read about it, which had some adage that what is designed to go wrong will always go wrong. And I think in 1978, some gentleman called Arthur published a book about that law. Here we are. What is supposed to go wrong will definitely go what? Wrong. Yeah, that bill, around 4 months after a historic decision by the Supreme Court of Uganda, we got a shock of our lives. Within a span of 7 days, a bill is tabled on 13th May 2025, and on 20th is passed. Unfortunately, or fortunately, we don't know what's happening. It's not yet assented to. So once it's assented to by the president, it becomes law. It means it will be gazetted and it will take effect. But as of now, it's still a bill. That's why there's no court what? Otherwise, you'll have seen a lot of issues. You'll have seen us going back to the Constitutional Court. One, on that bill, there's a memorandum, the object of the bill. Of course, the bill brought about so many changes in UPDF Act, but mine will be limited. I'm delimiting the whole debate to the issue of trial of civilians. The rest are maybe okay, because I saw a medical board being established and other things. So, that bill is bill number 15 of 2025. Is that bill okay? No, that bill is wrong. Why? First and foremost, in the object of the bill is the issue of the General Court Martial is legislated under Article 129, 1D of the Constitution. Now, for starters, the Constitution, Article 129, establishes courts of judicature. Now, courts of judicature are those courts which established under the Constitution. It starts with the Supreme Court of Uganda, which is the final appellate court, and then the Court of Appeal, which can also which puts on the heart of a constitutional court. That is where there are 5 judges, or where there's a question involving the interpretation of the Constitution or a reference of a question which has an impact on interpretation of the Constitution. Then there's the High Court, which all of us know. Then the subordinate courts. Subordinate courts are lower courts. These include Kadi courts, Chief Magistrates courts, Buganda Road, Nakawa, you know them. Those are subordinate courts. So, what is the problem? The first problem is the General Court Martial, Parliament creates it as a subordinate court, pursuant to Article 129, 1D of the Constitution of the Republic of Uganda. Then what happens down there when they establish a General Court Martial? They say the chairperson of the General Court Martial must be somebody who qualifies to be a High Court judge. Now just look at that, look at that conflict. The court is subordinate. Ordinarily, this is the Buganda Road Court or a Kadi court. That's their status under the law. But now what is happening is being headed by a person who qualifies to be a High Court judge, but a brigadier by rank and above. Now, there's something interesting. If a suspect is maybe a major general, higher in rank than the chairperson, the high command elevates that the chairperson's rank to that level of a major general, acting as a major general during the time when the case is on. So when the case ends, the person comes back as a what? As a brigadier. So strange. And then, as if that's not enough, of course, you know, for you to qualify to be a judge of the High Court, you must have been a judge of a court which has both civil and criminal jurisdiction. It entertains both things. And then, you must have been an appellate judge for 10 years minimum of a court from which that court appeals to. Or you must be a practicing advocate who has been practicing law the way we do, these gentlemen and our colleagues here do for 10 years. And then you qualify to be, that's the minimum that the law sets. Or you must be in public office, but where you were employed, you should have been employed as an advocate. Meaning if you're a legal officer, then you've practiced for 10 years. The whole thing is you must have some experience. Now here we are. Yeah, I don't undermine our colleagues who are in the forces. Most of them actually practice, especially in UPDF, police, prisons. They practice in their own way. Now, that's not the whole issue. The Supreme Court, the real issue with this court was that, one, it was not independent. And by the way, the decision of the Supreme Court was not only to help civilians, but also members of the armed forces. I mean, if you are appearing before a court under Article 28, the court must be fair, the court must be independent, whether it's a tribunal or not. Now, that was the problem with our military courts. First of all, the Supreme Court told us boldly, I remember that argument, I made it while making submissions, when I told their lordships, and when I was being probed, I think some of you were there, by the Chief Justice, whether my problem was the court. Did I hate people who sit on the court? It was a tricky argument, but I think we wriggled out of it and said, no, our problem is us who have practiced for a very, very long time still have problems with the ingredients of murder. Every day you go to court, you still restate the ingredients. You don't come up and say, me, I know murder. So, what of these untrained people who are not lawyers? You want them to grapple with something we ourselves, who have practiced half our lives on this earth, we are still grappling with these things. You've seen, even in court of appeal, people make mistakes. Judges, the law is not something you can just say you've mastered. So our problem was the people who should go and operate patients in Mulago should not be just highly educated journalists and lawyers and politicians, but specialized people who qualified in that respect or that field. So here we are. Now, for a court to be independent, one, there must be security of tenure. That's why you see people, when they are appointed as judges, they have security of tenure. But what's happening in this amendment bill? They don't have any security of tenure. They are going to be on 3-term contracts, which are renewable. There's a problem with that aspect. When you are renewing contracts, when somebody dangles that you're on a 2 years contract, which will be renewable, you must be at the person's beckon. Now, leave that one alone. The High Command now makes the decision of appointing with the help of the Judicial Service Commission. Now, these are not the things we said, and this was not what the Supreme Court said. 3, there's the aspect of autonomy, prosecutorial autonomy. Under Article 120, the DPP is independent. The DPP comes and prosecutes, the DPP comes and prosecutes somebody. Now, once the DPP is prosecuting, he's at the equal footing with me, the defense counsel, and we're all officers of court. Now, imagine a scenario where the DPP is part of the court. You understand? Now they have formed a department, Court Marshal's Department in UPDF, where everybody is in that department. Just now imagine the judges are seated in a department together with the DPP, together with the Attorney General. Where do you expect justice? You know? Now, apart from that, civilians. There was a contention. I remember Justice Monica, in her view, she did not see anything wrong with a civilian who is caught with a military personnel, because there's that offense of aiding and abetting. If they find you with somebody, whether you've not done the thing the way the person has done it, you might aid the person or you might abet. So I remember the judge mentioning that. The bill captures that. But now there's the other aspect, which is so funny. The bill says everybody who is subject to military law, actually it defines a service offense finally, as offenses which are under the Act, the UPDF Act. But somewhere, for civilians, you can be charged with murder, robbery, maybe theft, and I think soon they will charge people with the elopement and the trespass. I mean, they have opened it widely, you know. They have opened it widely. You people, why we've been struggling is, you see, if you look at the architecture of the civilian justice system, there's an independent body which does investigations, whether it's led by prosecution or not. You go to police, you report a case. The police investigates this case. They submit the file to a state attorney. A state attorney peruses the file and finds out small problems. Say, no, let this file go back. Then it comes back. It is sanctioned. It goes to court. Now, once it's in a court, you know the rest of the process. Now, imagine a scenario where the whole investigation is done by DPP, and they're the ones also going to prosecute. So we have a very, very big problem. All of you have been reading these things. VCJ was supposed to be due for trial in the General Court Martial. What happened? When the file was transferred to Nakawa, one, the original file for which VCJ was charged was not the file which was transferred. Two, investigations are not complete. So, what were the people in General Court Martial going to prosecute? By that time, remember when Martha Karua, senior counsel, was struggling with a short PC and a temporary PC. Questions were, the whole issue was, trial was ready. But now in the civil courts, the trial is not what? We don't know what is even taking place. So, There are so many ills with the UPDF amendment bill, and I think at a rightful time, once it's assented to, it will be challenged. Because the whole thing is now red beret. Pistol is one on Schedule 7A. A pistol is one of the things where UPDF has monopoly. The last time I remembered, I saw police officers holding pistols. I saw civilians holding pistols. So what are we going to do? Are we going to withdraw? Now, when I was representing Aguma, a former police officer in the General Court Martial, he was charged with unlawful possession of firearm. Honestly, how do you charge a policeman who is supposed to be holding a firearm of holding it unlawfully? So, and we came to court. Justice Undo Margaret, she has retired, quashed the charges. You know, now it's the same thing. And really, why must you subject? What is wrong if we say, you know, the offense of firearm, unlawful possession of a firearm has been there in our statute books. Actually, the law says, the Firearms Act says that it's only the High Court which has exclusive jurisdiction. So it covers all these things. And then, of course, there's been a lot of misrepresentation that there's quick justice in it. It's not there. I represented a group of Guti, Lakara. There has been, you remember the Kazinis when they were charged, maybe some of you were still in primary school. I'm sorry. I'm so sorry. When those people were charged, we don't know what happened. Tumukunde stayed in that court for over 10 years. Is that the swift justice we are talking about? No, let's not be hypocrites. The truth is, this thing is a monster. But I want to assure you, once it is gazetted and assented to, it will be challenged. Thank you so much. Wish you well. Thanks for your time.
Thank you, Senior Advocate Caleb Alaka, for giving us an insight into the ills, into what is happening at the court martial and the UPDF Amendment Bill 2025. Thank you. Our next speaker is Advocate Zadoch Opolot, who is our Senior Legal Officer with the Moroto Clinic. He holds a Bachelor of Laws degree from Islamic University in Uganda, Kampala campus, and a postgraduate diploma in legal practice from the Law Development Center. He is our senior legal officer, Legal Aid Project, and is based at the Moroto Legal Aid Clinic. He has over 8 years in legal practice. His specialty is human rights. He is passionate about civil and criminal litigation and represents indigent, vulnerable, and marginalized persons. He directly represents the suspects before the ordinary court and the court martial, and he is here to share with us his experience. Mr. Zadoch.
Thank you. As introduced before, I respect the protocol. Ladies and gentlemen, I'm here to share, to pick up from where my senior brother, Caleb Alaka, has stopped. And specifically, I will go to the experiences in the General Court Martial. At least I've attended, I've represented some clients there, and including holding watching brief on some of the ongoing cases. Now, and specifically I'll go to the report on the implementation of Order number 4, in the case of the Attorney General versus Michael Ziguruka, in the Constitutional Appeal number 12, 2021, which was recently passed. And under order number 4, specifically provided, or the judge directed that pending trial of partly hard criminal cases that follow under the civil law court's jurisdiction, which were against the members of the UPDF and civilians therein, be transferred to the civilian courts vested with competent jurisdiction to try them. Now you'll find that in the context of Karamoja and in other areas, the most victims or suspects that have appeared before these courts have been the Karachunas. And you'll find that the Karachunas is a name, is a generic name given to the youth, the category of the youth and individuals who particularly got involved themselves in the cattle raids by use of guns or use of the arrows, spear and the arrow, the burned arrow. And while doing that, they were raiding cattle, and this escalated from community to another. And in the bid to curb that, the security agencies constituted themselves into, there's a ASTU, there's a wing within the police that is tasked with, it's called anti-stock theft unit of police, and the UPDF. So these ones work in hand and have established so many detaches within the region to curb that crime. So these cattle raids are normally characterized by insecurity, and this big ancient cattle raids don't just stop yesterday. It started yesterday. It has been ongoing, and the motives behind were issues looked at creating wealth, or prestige, and then also getting cattle to marry for marriage. So you find that motivated these people, the warriors, to go after the cows. But while curbing the vice, security agencies employed measures which were drastic in nature. One of it involved the cordon and search. Let's say this is a village. In the morning by 6 or 5, you wake up, you are under siege. And one by one, they conduct a search on each of you. And if they have information on you, maybe it's a rumor that you are in possession of a firearm, you are taken as a suspect. So these people ended up there. You are taken, you are interviewed and interrogated, and one of the centers you are taken up at is detaches. And in a while, especially in the year 2022, when there was a security, you'd find that the suspects are taken to detaches, and thankfully, with the collaboration with the Uganda Human Rights Commission, the Office of the UNOHCR, we worked in hand, want to track those cases. Also the numbers. Why were we tracking the numbers? There are some relatives who were reporting that their relatives were missing. So we would put to account the arresting officers or the commanding officers to explain the whereabouts. And before you know that, some of the suspects would be transferred to many areas like Soroti prisons, they would be taken to Amita prisons, and that's in Abim, and then even including Akapiripiri and Moroto. So that brought about violations. There were violations because these are not people who are trained like as police officers, much as police officers are also keep undergoing what? Trainings. But when a suspect tells you how it was handled, so most times they're inhumanly handled, they report to you. In most cases, they would be told, we are buying you a 6-inch mattress. So all of you as suspects, you are going to sleep under a 6-inch mattress. So what happens is that you make lines, you squat, then you fall backwards on each person that you are resting on until morning. Can you imagine that? So that's called a 6-inch mattress in those terms. So suspects would be charged with various offenses related to cattle rustling. And they used to be, and up to date, you'd find a DPP and the army struggling for these files where who has the mandate. Whereas some files, in fact, ended up in the DPP at court, but still, at that time, we're struggling to have the physical files. For us, we're demanding to peruse the files and to see what the nature of investigations were or the accusations. The only thing you would see is the charge sheet. And when you ask your friend, the state attorney tells you, for me, this is what I have. And the files are still under investigations. So, based in the region, we managed to reach about 1,077 suspects. And these were arraigned before the Chief Magistrate's Court in Kotida, Bim, and Nakapiripiri. And then also, out of those, 586 benefited from the legal aid. And this is how we went about it. One, since we were jointly moving with the Human Rights Commission and the Office of the United Nations High Commission for Human Rights, then before it was disbanded, I would say, or it ceased to operate in the country, would go physically. One, demand for unconditional release of the suspects, because we found, because I wonder where you bundle up the entire village, take about 30 or 40 people from it, and then the next day you are taking them to court. So one wonders whether you have done investigations and even the nature of evidence you are using against them. So 491 cases remained in the 3rd Division Court Martial at that time. So those cases went on until we put pressure. Cases got dismissed. We demanded that these people did not have any case to answer at that time, though there were backlashes. And up to date, the backlashes are that, that all the accusations is that when the security officers are killed during operations, we as advocates or lawyers or the human rights defenders never come out to defend their rights. How about these warriors or the suspects? But the argument is simple. Government is vested with all the necessary resources, okay? And which should be accorded, including advice and streamlining which roles someone's supposed to do. So like what my senior brother talked about, these courts are normally constituted by the chairperson, who is most senior, maybe in the rank, and others, and one judge advocate, as they call him, and then the others are just members, lay persons. And I tell you, during deliberations or before a ruling is passed, you are told maybe to step out for 30 or 1 hour as they deliberate. And those are the same issues that the Supreme Court found. That these are lay people, they are deliberating on legal matters, and the decision is passed by consensus or by the majority. So these are some of the issues that we've had in interacting with this court. So currently, there are 63 suspects. The recent the recent information we have, which is verifiable, there are 63 suspects that were informed who are still held at the Moto government prisons. So in the wake of the judgment of the Supreme Court, indeed we went, and as our duty as the Uganda Law Society, we went and sensitized them on the judgment and the orders that were passed. I can tell you the information was received with joy, celebrations and glimpses of hope that these people's cases or the suspects would be transferred to the civil courts. But I tell you, up to now, it has turned out to be a disappointment. Each time you visit a prison, you are asked, counsel, you told us the other day, it's now 4 months, that our cases would be transferred to the civil courts. What has happened? What we did, we organized, we had to go with the regional state attorney. We told him, could you explain what the principal could be saying? And the answer was, there has been a constituted task force to handle each and every case. But for how long should this take? So, up to now, the office of the DPP, which was tasked to undertake or to facilitate the transfer of these cases, is stuck. So we are wondering whether the office of the DPP is alive to the tenets of the Constitution that refer to fair trial for persons whose liberty has been curtailed and who are still presumed suspects or innocent. So we're also wondering to the responsible officers in that office whether or how long should these cases take place? Do they have, what could be the issue or the gap? We need to interrogate, or the office of the DPP should come out, because, or any other person responsible. But as far as we know is that the DPP was tasked. So is there a gap in manpower, in the human resource? We need to understand why is it taking long for them to communicate or to give the taxpayers update on what their mandate is about in respect to this issue at hand. And in most cases, recently, the suspects themselves, thank you. So the suspects themselves have asked now, I'm happy to report it here, that if there was a way, if the office of the DPP is incapacitated in reaching, especially the Karamoja region, they are willing to sell any of their possessions. Can you imagine that? To facilitate the office to reach there to attend to their files, if the issue is the distance to reach to to the area where they were being prosecuted from. So do we need to reach that level? So briefly, I would say maybe we still have hope, maybe, that the orders of this court will be respected. And I wish to end there. Thank you.
Thank you, Zato, for sharing your experiences with us as you represent the Karachunas in the Karamoja region. Allow me recognize the presence of the Vice President, Uganda Law Society, Mr. Anthony Asimwe. You're welcome. We're happy you could join us. We have a third speaker who is joining us online, Honorable Medad Lubega Segona. He holds a Bachelor of Laws degree from Makerere University and a postgraduate diploma in legal practice from the Law Development Center. He is an advocate, a politician, and a member of Parliament of Busiro County East Constituency, Wakiso District. During the landmark case of Attorney General versus Michael Kabaziguruka, he ably represented the respondent, and today he is joining us to discuss with us the topic, Civilian and Military Separation of Powers, a critical examination of the UPDF Amendment Bill 2025. Honorable Medad, if you're online. All right.
Thank you. Hello. I hope you can hear me.
Yes, we can, Honorable. Please go ahead.
Earlier on, I had issues with my network, but thank you very much. And I want to welcome the Vice President and the entire team. I want to thank colleagues that have made presentations before, part of which presentations I've been following. And I want to say that I've largely been fortified by the presentation of Mr. Caleb Alaka, my senior colleague with whom we handled this case. Colleagues, I think we need to get to the background of how we started and applaud Uganda Law Society in this otherwise very tedious journey. In the year 2005, following again the incarceration of Dr. Kizza Besigye and a number of others, and the siege of the High Court, we were instructed by Uganda Law Society to go and challenge the siege of the High Court, the concurrent trial of the accused persons, both in civil courts, that is the High Court, as well as the General Court Martial in March, India. For me, I was 2 years in practice then, and my view was that we should have attacked head-on the monster called military justice. Unfortunately, as colleagues that were senior to me were of a different view and felt that it would be interpreted as political. So we missed that opportunity. Nonetheless, the justices of the Constitutional Court hinted onto this matter and this court as being unconstitutional. Even with what seems to be a win in the Supreme Court on 31st January 2025, I remain a little dissatisfied that the Supreme Court did not pronounce in no uncertain terms that these military courts are actually not courts within the meaning of our Constitution. I remain dissatisfied with the notion that they are even subordinate courts. Looking at Article 210, Parliament did not have the power to establish a court under the UPDF Act because the Constitution was specific on what Parliament would legislate on in enacting the UPDF Act 2005. And it proceeded on discipline, recruitment, deployment, and the last word is and. There were 4, A, B, C, and D, meaning they could not exceed or go beyond the 4 corners of those 4 clauses. That said, we have moved past that. Back to the topic, civil and military separation of powers. When you talk about the separation of powers, it is a recognition that different agencies and organs of government would play different roles. We have never downplayed the critical role played by the UPDF in securing our borders and therefore protecting us against external aggression and engaging or participating in self-help community issues. We have issues in Bududa. We need strong men and women who can help in averting the effects of the catastrophic landslides. But we have never sat anywhere as a nation to agree that the UPDF would be useful in delivering a service called justice. So the transgression by the UPDF into a territory reserved exclusively for the judiciary is not only unconstitutional, it is criminal because it undermines the 4 corners of our constitution. It is actually not allowed to cross because the judicial power under Article 126 is exercised by the judiciary for, in the name and in accordance with the aspirations of the people of Uganda. So we have never empowered and empowered the UPDF to undertake that critical role. Separation of powers essentially means and connotes that nobody should cross into the other's territory. It connotes checks and balances. We agreed that while Parliament may be useful, Parliament will not cross into the realm of interpreting the laws and the constitution for the country, because that is not reserved for us. Indeed, we are required as an organ of government to give effect and to give all manner of assistance to the courts of law in matters where they have made findings. Now, by interfering, we are in breach of Article 92. I would interest colleagues in reading the detailed minority report that we put on the floor of the House in response to the proposed amendment, to the UPDF Amendment Act. And this is how it happened. 1, we did mention that we are not allowed under Article 92 to make retrospective legislation, a legislation that not only pronounces itself, but has the effect, with the effect of overturning or interfering with the decision of the Supreme Court. What did we have in the bill? What we had in the bill was a replication and a reproduction or reenactment of the of Section 117 of the UPDF Act, which was declared unconstitutional by the Supreme Court. First by the Constitutional Court, and secondly by the Supreme Court. 2, the Supreme Court was categorical. Under no circumstances will you prosecute civilians in a military court. But they said, in exceptional circumstances. So you and the Supreme Court went ahead to say, those exceptional circumstances are circumstances where there are situations where the civil courts of Uganda are not functional. So is there any place in Uganda where civil courts are not functional? No. Probably in Somalia, if you are at war, the civil courts are not able to function. and you're not in a position to transfer the suspects back to Uganda. Those circumstances do not exist anywhere in Uganda. Two, the Supreme Court also held that where, and Council Kalibalak has hinted on it, offenses which are within the exclusive jurisdiction of the High Court cannot be prosecuted in the courts martial. Why? Going by what I consider to be an erroneous view, even on the part of court, that these are subordinate courts. You cannot take the same offenses prosecuted before the High Court to a subordinate court. By doing so, you would be elevating the so-called subordinate court to the level of the High Court. And that function is not a function available to any organ or agency of the state without amending the Constitution. And now you cannot amend the Constitution to achieve it because it would be an affront to Article 92 of the Constitution. So you have interfered with the judicial power, you, the legislature, and you, the executive. I think a justification has been placed before us that, you know, security, etc. Just imagine a situation one day when we do not have a functional police force in Uganda. Equally, there will be catastrophe. But there is a sense, an exaggerated sense of self-importance on the part of our men and women in uniform, or officers and men in uniform, in saying that where we do not exist, there will be catastrophe. Yes, there will be catastrophe. That's why we want you to exist, but exist in accordance with the law. We love the UPDF, but we love Uganda more. We respect the UPDF, but we respect the Constitution more. Because without a Constitution, or without respect for the Constitution, there will be catastrophe. Everybody will be doing things their own way. While considering the bill in our retreat, I think we were moving well until we had interference from what they call the NRM caucus that sat in Entebbe. And the president made a directive. I want this bill the way it is. We had agreed on a number of areas which are not controversial. For example, on the pension for our servicemen, the medical for our servicemen and women. We were at par, we were in agreement. Now, looking at the interference and the civil and military separation of powers, we also looked at offenses of a penal nature. The Supreme Court was categorical. In effect, the Supreme Court told you that the military courts or the courts martial can only handle service offenses, and service offenses are offenses which relate to service within the UPDF. We have a disciplinary committee in the police. I think even in prisons. It has no business with us who are not members, but equally has no penal powers over their men and women. Offenses of a service nature would mean and include those that relate to military discipline. You are not wearing your uniform well, your shoes are dirty, things that bring into disrepute. And the penalty would be of a civil nature or disciplinary, dismissing you with disgrace, lowering your rank, or even removing your ranks. They cannot extend to those that take you to prison or giving you a penalty of a custodial nature. I think Councillor Laka has also talked about the justification of so-called quick justice. I think what the military does is to provide a quick injustice. Whereas there is saying that justice delayed is justice denied, equally justice hurried is justice buried. Look at the Dirang prosecutions or massacres in Karamoja, where people were prosecuted without due regard to due process. I had a discussion with a colleague from Karamoja, a colleague MP from Karamoja, who told me actually they massacred people who had not participated in the murder of Father Olturi. I hope I'm pronouncing the name well. The person who actually murdered the priest was later found by a colleague from Karamoja, having been in Fort Portal, having been promoted to the rank of a captain. They got people who did not participate, but in a show of might and probably right, executed them within less than an hour. So you bury justice at the cost of the altar of convenience. Now, do you have a judicial environment in that military court of yours, where you go and a military officer called a court orderly decides that a lawyer, an advocate duly instructed, will not access the bar? This is what you witnessed in the case of Counsel Aaron Kiza. That this man tells you, you will not access the bar, and that is a court orderly. How different is that from the prosecution of Caleb Alaka and Lord Mayor Arias Lukwago, way back in 2005? Counsel Caleb Alaka protested and said, Mr. Chairman, for the first time we remove a lawyer who is robbed from the bar to the dock. And the chairman says, shut up, we have seen lawyers robbing other people and we have sentenced them. Democratic oversight connotes that you carry out oversight democratically. And democratically connotes in accordance with the Constitution of the Republic. Did we see that? Is there an environment? I was supposed to be prosecuted, by the way. When I went to represent Caleb Alaka and Arias Lukwago, co-counsel, senior counsel Sam Kaliga and Juba said, this is the kangaroo court. General Tumwine thought I had said it, and that with my height, he thought I was a candidate for prosecution. He said I should cross to join my clients in the dock. When Counsel Njuba owned up and said, I said it, he said, you're the one who said it? Never repeat it. But if it was me, Medad Lubega, I was supposed to join my clients and be prosecuted with them. In the final analysis, I can only say this, ladies and gentlemen, that this is a fight for all of us. Okay? There is no court in the court-martial. There is no justice. Let me talk about this transition, so-called, from the military courts to the civil courts of these files. Pending transfer of these files, these people who are in prison, on whose orders are they in prison? Go back to Article 23. Nobody can be deprived of his liberty except with an order of court. With the declaration that this is not a court, who ordered for the detention of these people? For how long are they going to continue? Who said the DPP is at liberty to take her time in this process of transferring files? By transfer of files, did the court say that they should also transfer prisoners? There is no provision for transfer of prisoners. The court said transfer files. Actually, if the police were empowered enough, I was going to say we're intelligent enough, and I knew it would not go down well. If they were empowered enough, on that very day, they should have waited from the gates of these prisons, have the suspects released by prison, rearrest them, present them in court in 48 hours as required by the Constitution. But only if they have files against them. If the UPDF were not smart enough, as I believe and agree they are not smart enough, to transfer these files, these people would be let to go. I think the most dangerous thing we have seen, probably done or participated in, consciously, subconsciously, or unconsciously, is to individualize institutions and institutionalize individuals. When General Muhoozi Kainerugaba said that Dr. Besigye will leave prison when he's dead, or on his knees pleading with General Museveni, every institution started trembling that if we do the right thing, we'll be in trouble. Now we witness a situation where the Attorney General wrote an opinion, and the opinion is that you hold them until transfer. Since when did the opinion of the Attorney General of Uganda become a source of law? I thank you.
Thank you, Honorable Medad, for sharing your views with us on the UPDF Amendment Bill 2025. And like you rightly said, it's a fight for all of us. We'll right away go into our Q&A. Our first question is from Kato Jimmy. And the question is to you, Honorable Segona. On the issue of public participation, a petition was made to Parliament asking for a referendum. If the bill is assented to and later repealed, would it be retabled and a referendum called? Because that is what Ugandans need. I'll repeat the question. On the issue of public participation, a petition was made to Parliament asking for a referendum. If the bill is assented to and later repealed, would it be retabled and a referendum called? Because that is what Ugandans need. Our second question goes to Council Alaka. If Parliament went ahead to pass a law inconsistent with the Supreme Court judgment, what is the remedy? That is broad day abuse of a court judgment. What can the layman do to address this? Then there's a third question. Besides Dr. Besigye and Counsel Aaron Kiza, do you know of any other civilians, probably any of your clients, whose files were transferred to civilian courts? Or do we want to say that the ODPP has not done anything in respect to the Supreme Court decision? Those are our questions. We'll start with Honorable Segona.
I want to thank Jimmy for the question. If a bill is repealed, you do not retable it. You go afresh. You present a fresh bill if it is necessary. That's number one. But there are also an option of taking it to court. Because if we take it to court, the court will strike out only those provisions which are unconstitutional. My fear with the current bill, including the good provisions that we had agreed on that relate to the welfare of our officers, is that the process, once the process is successfully impeached, like, for example, the lack of public participation, which was said in, if you remember, in the Malema Bills and others petition in Bali, was said not to be a cosmetic exercise, but a critical exercise in accordance with our constitution. That means, therefore, the lack of public participation would lead to the nullification of the entire process, and we shall lose even the good provisions in the bill. So, if it is nullified or repealed, you would go back afresh and present a fresh bill. I'm done.
Thanks. I think that was still from Jimmy about the effect of Parliament passing a law which has an impact or reverses a decision of the court. Of course, that is prohibited under Article 92 of the Constitution. And there are remedies. We have full access to court. And I think, as Honorable Medad Segona said, this struggle did not begin today, and we are not about to give up. So let's just be ready to go back to court and challenge this law. I think that's one of the reasons that they have delayed to gazette, to assent and gazette to it. But it will be challenged because it's unconstitutional. Thank you.
Council, there was a third question. Besides Dr. Besige and Council Aaron Kiza, do you know of any civilians, probably your clients, whose files were transferred to civilian courts, or do we want to say that ODPP has not done anything in respect to the Supreme Court decision? Thank you.
Yeah, thanks. I'd forgotten that. I think there was a status report also presented to Parliament where several files were actually transferred. The ODPP has done a lot as far as that is concerned. But the only problem now is, as my colleague has said, like the case in Karamoja, there are also an absolute great number where there's been inaction. Yes, how much? 63 in Karamoja, yeah. But personally, I don't have some specific clients. I don't have, all of them were transferred, yeah.
Maybe if I can add something onto that. One, we have witnessed lists that have been submitted to Parliament, that the following files have been transferred to courts of law. But that does not necessarily mean that the suspects have equally been submitted or produced before civilian courts or civil courts, as it were. And therefore that they are under management. When they say we have transferred, they pick files and send them to the DPP. So these people get a list that has been received by the DPP and bring to us. I think let me not stop at criticizing or critiquing, but be useful to those that have decided to be less useful. If this was an organized way of doing things, the police would have engaged the UPDF to look at the files, review the files, and see those files which have evidence. Then the police would pick interest in those ones with complaints. Because you see the trouble, when you go to the UPDF system, you have no complainant. The transfer of the file to the police system does not necessarily bring a complainant. So who is complaining that I was putting on a beret? Nobody. I have also some experience with how UPDF does things. One, they pick you from wherever they pick you. They get a folder. If Councillor and others were keen enough, you would notice that whenever you would enter the court martial, the chairperson and the rest of his members, whenever they would come back to court, they would come with a new file folder. They would also come with blank pieces of paper. They would write fresh notes. Indeed, for you to get a record from the court martial, if you are proceeding on appeal, or it is required by the High Court, would be next to impossible. In the case of the Honorable Michael Kabazuguruka, when we first went and applied to refer the matter to the Constitutional Court, and they refused, asking them to give us just a copy of the order where they said they have the powers or jurisdiction to try civilians and military officers. It took us 3 months just to get that one-page order. And I will not mention who hinted to me that just draft the order as you had it. Otherwise, there is no record. So even these transfers you're talking about the transfer of blank file folders. At some point, I was a suspect in 2008 when I was kidnapped and taken all over the country, Western Uganda. I was interrogated 7 times. Whenever those people would be coming, they would be coming with blank files, folders, blank papers, and there was no complainant. This is the same case. I think in the final analysis, because I want to go for another meeting with your permission, what we are dealing with is the persecution. Do not be surprised, because I have information. As soon as this law is assented to, whether we challenge it or not, Honorable Robert Sentamu Kyagulanyi is the first person to be prosecuted under the new law, under the new regime. There is also a plan to delay transfer of these persons who are in prison now, so that when they reconstitute the UPDF court, the court martial, they just continue prosecuting these people, even when the prosecution was declared a nullity. So I think it is time for everybody to get up. We pump sense where there is no sense. We add sense where there is little sense. I thank you.
Thank you. We've come to the end of the session. Allow me to thank our guests today. We do not take your presence for granted. Those online, we thank you so much for sparing your time to come and impart wisdom on us this afternoon. In a special way, allow me invite the treasurer to say a word.
Good afternoon, ladies and gentlemen. Allow me stand on the already observed protocol. Before the Vice President coming in, I was supposed to make a vote of thanks. However, I'll leave that to the President, to the Vice President, and I will make a few remarks as the Treasurer. First of all, let me thank our visitors for showing up today. The Uganda Police, the sensitization that you have done, Senior Counsel, Kale Balaka, we do appreciate the changes that you have done in the criminal and constitutional department. Dr. Lobogo, who has shared some insights from Nairobi, really good insights about this new trend of the EPS. A comrade, advocate, Stanley Okecho, thank you so much. And Mr. Zado Opolot, who is our legal officer in Moroto. The last time I interfaced with Council Opolot was in November last year. And I can assure you he has really done a good job in Moroto. In Moroto, for those of you who do not know, we have a shortage of lawyers in Moroto. I think most lawyers prefer to practice from urban areas, especially within central Uganda. So that leaves a vacuum in some areas, and it is lawyers like Mr. Opolot that have stood the test of time and have actually covered that gap that is left by many of us to enable or ensure that the members of the public, in those areas can actually have access to justice. You see, access to justice may sound more of a slogan, may sound more of a word. It may sound easy, especially if you have access to a lawyer. It is very easy, but if you visit those areas where people are incarcerated, I can assure you, just a mere look at a lawyer can give relief to someone who is behind bars. So it is lawyers that, like Mr. Oprot, that give people such an opportunity. Of course, Honorable Medad Lubega Segona, the MP, Busiro East, we thank you so much. Those are some of the lawyers that we have in Parliament. The Vice President has always re-echoed that there should be as many lawyers as possible in this upcoming election, 2026 elections. As the Radical New Bar, we call upon many lawyers to engage in the elections, the upcoming elections. Because this is the chance that you have. This is the chance that you have to influence policy. Parliament is an area where people legislate. They come up with these laws that we are debating about, these laws that are actually affecting us, are made by people in Parliament. So the chance that you have, even new people that are here, this is the chance that you have. I always say chance comes once. Now chance has come. It is 2026 is just knocking on the door. Please take up that mantle. Talking about civil and military separation of powers. The bill or that anticipated law, the UPDF Act, that is intended to streamline probably behavior and many other issues concerning how military affairs are being governed. It's a good law within the military circles. I believe all Ugandans know that act is a good law. But when you direct that law to civilians, then that's when it becomes a bad law. That is when you usurp the powers of the judiciary. Last time I talked about it and I said that this is a coup, and I insist this is a coup. This is a coup on the judiciary. And the Attorney General should advise government. Of course, we know the politics behind the curtains. Sometimes I feel sympathy for politicians because there is a lot that happens behind curtains. And you feel sympathetic about them. Maybe they have to maintain their jobs. You know, living in Uganda without a job is very hard. So sometimes some people ignore some things just to maintain their jobs. But we should look at the bigger picture. When I was looking at my phone, I saw a message from our PR department concerning the disciplinary action by Law Council. For those who do not know, Law Council is a disciplinary entity that is put to discipline probably lawyers, or if someone has a grievance on a lawyer, it is where they take their actions, and they always call the lawyer and the person who has a complaint on the lawyer, and they listen to each party and try to ensure justice is served. So assume a situation where some of, you have heard of lawyers who hold out. A lawyer who holds out, someone doesn't have the license, someone is not an advocate, but he impersonates, he masquerades as a lawyer. You have seen them, I believe you have heard about them. Lawyers, people who go to court, They say I'm advocate so and so, but in reality, the person is not a lawyer. So in such a situation, imagine that such a person had to be taken to law council. You take someone masquerading as an advocate, then you take him to law council. You are masquerading as a lawyer, and therefore you have subjected yourself to the laws that govern lawyers. So, that is what some people in parliament are advising government. That because someone has masqueraded around as a military officer, therefore you should subject him to military law. What is wrong? If you don't mention these things out, no one will mention them. If you don't talk about them, no one will talk about them. So that act, the EPDF Act, as my colleagues have been talking about, it is an act that is intended to weaken the judiciary. When we were in Moroto, the Chief Justice was very clear that sometimes he loves to see Uganda Law Society fight for the judicial space. That's something he talked about, that it is Uganda Law Society that has to fight for us as judicial officers. Because the judicial officer will never come out and say that the EPDF Act is shrinking their space. No judicial officer, even the biggest, the one with all the powers, the Chief Justice, will never talk about it. He will keep quiet. It is Uganda Law Society that will talk about it. And we are talking about it now. Don't take away, don't usurp the powers of the judiciary. Justice can be served within the courts of law as provided for under the Constitution. The courts are known. The Supreme Court, the Court of Appeal, name it. We have all those courts. They can deliver justice. Don't try to create an image that the judiciary is incapable of serving or doing its mandate. No one should try that. No one should try that. You see, the Radical Rnblive sessions, this session that you're seeing, is a session that Council, Uganda Law Society, came up with to ensure that the vacuum created by the failure to sensitize members of the society is reduced. We created Rnblive to reduce on that vacuum, so that we can sensitize, so that we can elaborate on issues, national issues. This is a national issue. And in fact, when I see ASP Pamela, it reminds me of the cries that some police officers in Uganda Police have been talking about. You see, Uganda Police has different categories of professionals. And one of the professionals in Uganda Police are professionals in the legal department. Do you know the sad story about professionals in the legal department of the Uganda Police? When the government came up with a policy to streamline salary and allowances of all judicial officers, including legal officers in police. They were put on the same pay scale. They were all earning the same pay with the judicial officers, meaning a magistrate was earning the same salary as a legal officer in Uganda Police. And they got the money. For the first few months, they got the money. But where the Attorney General gave advice that the people in legal department should not get the same pay scale as other judicial officers was alarming. It was alarming. And Superman will never talk about it. She will never. Because once you talk about it, you know the repercussions. Even the legal officers in police will never openly tell you about it. But all we are saying, let's improve standards. If by luck some people, or by merit or what, I don't know, but if they improve their standards of living, we shouldn't pull them back. We shouldn't reduce. In fact, we should fight to ensure that even those ones who are left behind are boosted in terms of salary increment as well. If you fight and the legal officers have got increment, then you should also fight for other departments in police to get increments in their salary. So, those are concerns. We talk to the powers that be. Please, look into these issues. You are the people who have the powers. God, right now as we speak, you have the powers and the authority to do that. Because I know this Rnblive is listened to by so many people here and in the diaspora. People are listening to whatever is happening here. Government is listening. So please, government, take action. Of course, the current topic is concerning the EPS tickets. Of course, the EPS tickets really are, these are very unfair. I know the spirit. The spirit is to ensure safety, and I'm going to talk about safety. But talking about the fines, by the way, have been there, and the surcharge has been there. And somehow people have been moving on, and they have been finding ways of paying and ensuring that they observe the road signs. But now, the government has intensified, the government has doubled their urge, the urge of money. Because honestly, for us commercial lawyers, we know that interest, worst case scenario, interest, if I fail to pay you, then I'm supposed to pay you back on. I'm supposed to pay an interest at a commercial rate. That means that if you demand me 1 million, at least in a year, if worst case scenario happens, you're supposed to pay 24% of that, an interest of 24% on top of the money that is being demanded. So here we have government saying that within 3 days, you will pay 50%. That is unfair. That is really unfair because one, you very well know that Ugandans earn salary. So you have to pay a fine within 3 days. Of course, once the police finds you, it is going to tell you first park your car and pay the money. So that inconvenience. So government should look into that issue of fines, the surcharges. They are really exorbitant. They're just, they're not corrective in nature. You see, the law should be corrective. The law should be put in place to correct. You correct an anomaly. Of course, in all that we say, we should not keep a blind eye on the most important thing, which ASP she has talked about, safety. Of course, as lawyers, we need to drive safely on the roads. Not even lawyers alone, even other people who are not lawyers. At the end of the day, safety matters. Your family still needs you. Your family needs you alive and healthy. So when you overspeed and you put your life at risk, you're putting your life and your family at risk. You're putting your kids at risk. Once the police officer says that don't sit in front with your kid, if your child is below a certain age, please follow. I think some of those regulations are put in place to ensure our safety as the road users. Of course, this goes to the KCCA, Ministry of Works. They should also ensure that at the end of the day, there are proper signs on the road. Yeah, there are no signs on the road. Once they put signs, and probably either it is either stolen by people who are looking for scrap, or probably in an accident the signpost was damaged. Sometimes they don't take the initiative to put signposts. So they should always put signposts to remind people of certain rules to be observed in certain areas. Put zebra crossings. Kampala is lagging behind in terms of infrastructure development. You buy your car, but you have to buy shock absorbers all the time. These are things as government is looking to prioritize on ensuring that they find the civilians. They should also look towards improving the infrastructure. I think government is lagging behind. To be honest, we are lagging behind in terms of infrastructure, especially within the city center. We are lagging behind. There are no pedestrian lanes. You have to, some for a few places this side of Upper Kampala. People who are in downtown, people who are in the suburbs of Kampala, there are no pedestrian ways, walkways where people have to move. You have to struggle. In other words, you have to walk vis-a-vis the border. You have to squeeze yourself, in the road. So those are things that government really needs to look at. Once that is done, I can assure you, at the end of the day, we shall all enjoy Kampala. So those are the few remarks I wanted to make. Thank you so much for listening to us and listening to our panelists. We pray that you take into consideration what has been said. Of course, to the lawyers, the advocates out there, as your treasurer, I want to inform you that we have resumed construction. You might look at this building and you think it is now fully furnished. Construction is still ongoing, and as you move around, you will see people who are doing construction activities. You will hear construction sounds from construction machines. So we are trying to ensure that the building is, we shall do whatever we can to ensure that the building is fully up and standing, to ensure that we fully utilize this building. So with those few words, thank you so much for listening to me. I will take with a great pleasure to invite the Vice President, who will make closing remarks. Please clap for the Vice President.
Thank you, Governor. We refer to our treasurer as the Governor Bank of ULS. And some of you have been following. At some point, the bar was broke, but I believe we are getting back on our feet. The council members, I believe our president is online, and other council members who are joining us, the treasurer. Our presenters for today, members online and those who are here physically, the members of the Secretariat, the Fourth Estate, and everyone who has joined us today. We also have members of the public who are online. It is a pleasure to have all of you. Mine really is to give a vote of thanks And in a special way, allow me appreciate our senior members of the bar, specifically Senior Counsel Kale Balaka. We've had Stan Lokecho and Honorable Medad Segona. Why it is important for us as the Radical New Bar, we had reached a point where some members of the bar thought the senior members of the bar decided to take a back seat and let us fight the fight alone, the young, members of the bar. And on behalf of the Governing Council, the Radical New Bar, allow me extend our sincere appreciation and gratitude. Your participation, your acceptance to participate in this does not only give us hope, but it also gives us courage to fight on, knowing that we still have senior members of the bar, have the spine, and who believe in the same vision we believe in fighting for justice, good governance, and rule of law in this country. We really do appreciate. Just so you may not know, I think I called Senior Counsel yesterday in the evening. Another person will tell you this is short notice. I cannot make it. I reached out to Honorable Medad Segona. He told me he was out of the country. And when I suggested an online appearance, he says, I'll spare time for that. So this alone is a sign that the senior members of the bar are with us in this fight. And we really do appreciate and thank you very much. We do not take this for granted. It gives us more strength and courage to fight on. Just so you may know, there are people who might not realize that what we are doing here, why we had this initiative, is because of the major focus on our statutory mandate under sections 3D and E of the ULS Act, which is to protect and assist the public in Uganda in all matters touching, auxiliary to or incidental to the law. How do you do that? How do you fulfill that mandate? And also to assist the government and the courts in all matters affecting legislation and the administration of practice of law in Uganda. All this is geared towards promotion of, rule of law and good governance. And we do believe that if we do not speak up as lawyers, if we do not speak for the voiceless, if we do not stand up for those who cannot stand and speak, we shall have betrayed our nation. The legal profession is not just, we call it a noble profession, but it's for a reason. We have a role to play. We have a role to play for the benefit of the members of the public. It is not individual. I may have my clients, Senior Erica and Senior Stanley, they've been here seated with us. They also have work and clients to attend to for probably their own financial gains. But again, we have a bigger role, which is the mandate we have under the law. And the sooner I realize that, the better. That each of us, as members of the bar and the legal profession, we should not only work for our stomachs, so should not only focus on our individual needs, but the needs of the general public. And a representative from police, Madam Kentaro, thank you very much. We have on several occasions invited for these events members of other institutions, the jealous actors, because whatever I usually discuss touches, other members, everyone has a role to play in the jealous sector. Of course, some of them turn down our invitations, others think other things are more important. But the reason we do this is that we can have meaningful engagement to shape the future and the governance of this country for the benefit of all of us. Because while there's a total breakdown of rule of law, it affects everyone. It is not going to spare anyone because they are government officials, or because someone is a minister, or because someone is seated somewhere, because his son or daughter. It affects everyone greatly. That is why we feel it is important to continue doing this. And we really do appreciate the members who have always attended, who have been part of this. Every week we have an important aspect, an important topic of discussion. You see discourse out there, but anything that affects or touches rule of law, good governance, and human rights, we have to come up and speak and give an opportunity to members of the public to participate. Now, with that, allow me give our official position and thoughts on the two topics that have been discussed. I believe our speakers today, I'm sorry I came in late, I had to preside over an enrollment process. Today, about 141 new lawyers enrolled, and I had to be there to welcome them to the radical new bar, because it's the duty of judiciary, but as ULS, we have to be there and welcome the new members. That is why I came in late. But I want to believe that we got insightful discussions. Beginning with the last topic, I have no doubt that Senior Counsel Araka delivered the most, speaking from the horse's mouth, that's what we call it. I had Honorable Segona's discussion, and these are the insightful discussions and knowledge sharing we need. Some members do not know all this. Some people have not had a chance. Those who have not attended court, those who have not appeared, they've not had chance to get this kind of, first-hand information. They speak from a point of ignorance. And others who have not taken it as a serious matter is because they lack this knowledge. The biggest challenge you have in Uganda is ignorance. And the best we can do is give back to society. So I believe the invaluable discussion really requires nothing much to add. It is what you've had is the position of the bar. But just to, to summarize it, we did have an official statement on the UPDF Amendment Bill 2025. You remember when it was being discussed in Parliament, they reached out, we issued a statement. But even as it stands now, we still have our official position, which is a sum up of what has been discussed by these members, and which is what we are sending out to the public and the powers that be, the relevant stakeholders, to take note of our recommendations and what we are suggesting. And specifically, the Uganda People's Defence Force Amendment Bill was passed by Parliament on 20th of May 2025 and now awaits presidential assent. Our position is that this bill is inconsistent with Uganda's constitutional order and established judicial precedent, especially from the Supreme Court. And these are the major points. One, undermining judicial precedent. Clause 1191G maintains the position that civilians can be subjected to trial before military courts. Now, this is in direct contravention of the Supreme Court decision in Attorney General versus Kabas Guruka, Constitutional Appeal number 2 of 2021. We've had the members here who argued that case, speaking to the, the depth of the matter and the reasoning behind the judgment. And this is where the court unequivocally held that the trial of civilians in military courts is unconstitutional, violating the right to a fair hearing before an independent and impartial court under Article 28(1) of the Constitution. The second concern is disregard of pending judicial proceedings. The Uganda Law Society filed case reference number 14 of 2025 in the East African Court of Justice, challenging aspects of the decision in Attorney General versus Kabas Guruka. We formally notified Parliament of this pending matter, urging caution and restraint in proceeding with legislation that would directly impact ongoing judicial deliberations. Parliament disregarded this concern and proceeded to pass the bill. And if you remember the time we received a call to attend, which is our third concern, which I'll, speak to more with this one I've spoken about, the lack of meaningful stakeholder engagement, that ULS received an invitation to present our comments on the bill 10 minutes before the time for this discussion. And this was a deliberate, intention rushing the bill through Parliament without proper engagement, which reflects dangerous disregard for democratic values, especially the perennial continuous doctrine of civilian and military separation of powers. I happened to be a teacher. I was in class, and it was around 11:50 when I received a call from Secretariat. Of course, by virtue of our position, we have that mandate. We guide, we advise Parliament on every law that is being passed. It's usually a 3 call that they ask for our input. Now, when this call is made, we have a membership of over 6,000. As the Secretariat, we don't generate these, opinions. We do share with the membership. The membership gives their opinion. The people who are skilled in that area of practice. And then we compile a memorandum which is shared with Parliament as the position of Uganda Law Society, as we are mandated by statute to do that. Now, this particular day I received this call and a letter from Secretariat at 11:50 calling me to go and appear before the two committees, the Joint Committee on Defense, I think, and Legal Affairs, to present our position as Uganda Society on the bill. This is a 150-page bill. Of course, it was impossible. You cannot make it between 10 minutes because the meeting was for midday. So what we did write back immediately and informed them that, one, it is on short notice. That shouldn't just be an excuse. We still gave our opinion. Told them, listen, there's a pending litigation in the East African Court of Justice. And the rules of Parliament themselves do not allow Parliament to go on discussing a matter that is pending in court, where there's pending. It is a breach of their rules of procedure themselves, I think Rule 75. That notwithstanding, the process went ahead, and we know what happened. So this is our call to action, and this is what the Uganda Society calls for. We do urge His Excellency the President not to assent to the EPDF Amendment Bill in its current form, because of the reasons we've given. We also demand a repeal of all provisions allowing military courts to try civilians. And then we also call for the bill to be returned to Parliament for reconsideration in light of constitutional standards, judicial pronouncements, and the principle of democratic governance. All these processes are flouted. That's why we feel, like Honorable Segona said, even the good parts of the bill, the good provisions of the bill, by virtue of the fact that processes have not been followed, they are also affected. It affects the very principle of legislation. So that is our position and our action on the UPDF Amendment Bill. And we also had an earlier discussion this week, the last week and this week. You saw the public uproar on the Traffic and Road Safety Express Penalty Scheme, these regulations of 2024. And we've taken keen note. That is why we've had a deep discussion about this, and you see what has been happening. Then again, also in exercise of our mandate, our statutory mandate to assist government and the public, we have an official position on this for guidance. And the Uganda Society has noted with concern the recent operationalization of the Traffic and Road Safety Prescription of Speed Limit Regulations 2025 and the Traffic and Road Safety Express Penalty Scheme Regulations issued by the Ministry of Works and Transport. We know these have temporarily been halted from the communication we are getting, but as they go back and reflect to make a proper decision on how to implement this, because we know the intention is to implement, and the intention should be a good one. We do request and call upon them to listen to this guidance before they take any other step. While the objective is to address the growing incidence of road traffic accidents and enhance public safety, the legality, constitutionality, and procedural propriety of these regulations ought to be checked. And these are our major concerns, the ones we picked from the regulations. One, there's lack of stakeholder engagement and public participation. The ELS is particularly disturbed by the absence of meaningful stakeholder consultations in drafting and implementation of these regulations. Public participation is the cornerstone of democratic governance. The enactment of legal instruments that materially affect the rights and obligations of citizens without consulting offends the principles of transparency, accountability, and participatory governance under Article 38 of the Constitution. And these are the procedural flaws we're talking about. Our second concern is the violation of the principle of personal liability. The speed limit regulations impose penalties on the registered owner of the motor vehicle, regardless of who was in actual control of the vehicle at the time of the alleged offense. This is inconsistent with the fundamental legal principle of individual criminal liability, because criminal liability is individual. It cannot be transferred. The ability for a traffic offense should attach to the actual offender, not an involved third party, and definitely not a vehicle, not a motor vehicle, not a motorcycle. This looks like they are punishing, the punishment goes to a vehicle or, a motorcycle. In cases of borrowed vehicles, hired purchase agreements, or company vehicles, such blanket liability on owners is unfair and illegal. Now, our third concern is that there's conflict with existing legal framework. The traffic and road safety rules, that is rules of the Road Regulations 2024, are still in force, and they already prescribe lawful speed limits of 50 kilometers per hour. And this is in built-up areas and 100 kilometers per hour outside them. The existence of pyro and conflicting regulations creates legal uncertainty, and this is very dangerous for any community. The fourth concern is unreasonable and punitive deadlines. The imposition of a 72-hour period for payment of fines under EPS is arbitrary, and the 50% surcharge is neither backed by law nor in conformity with the socio-economic realities of the majority of road users. This practice amounts to arbitrary punishment and disproportionately affects the economically disadvantaged, meaning if you're not able to pay this within 72 hours, then it doubles. This is absurd. I've seen in developed countries, I don't know that we borrow or that we benchmark, where someone is issued with an express penalty. If someone actually pays this money within a month, they pay half of the money. They are, you know, they are given that motivation so that, to pay. So now here it is done, it's the opposite. So we feel this should be taken note of. And the fifth concern is restriction of fundamental rights. The regulation bars individuals with outstanding EPS tickets from renewing their driving licenses or exiting the country. Such administrative sanctions raised infringe upon the right to liberty and freedom of movement under Article 23 and 29(2) of the Constitution. And we believe this is also unconstitutional and uncalled for. And then the sixth concern is excessive and arbitrary penalties. Penalties under the EPS, particularly those ranging from 200,000 and above, for minor infractions such as slightly exceeding a 30 km per hour speed limit, are excessive and punitive. Such fines do not reflect a reasonable correlation between the offense and the penalty and are likely to amount to economic exploitation. Now, these are our recommendations as the Uganda Law Society, that in light of the above, the Uganda Law Society recommends the urgent commencement of an inclusive and participatory review process involving key stakeholders, including legal experts, civil society, transport operators, and the general public. Secondly, we urge Parliament to exercise its oversight mandate under Article 79 to ensure that statutory instruments are consistent with constitutional norms and do not impose disproportionate or unjust administrative burdens. The Uganda Law Society reiterates its commitment to upholding the rule of law, constitutionalism, and the protection of civil liberties. And any efforts at improving road safety must be pursued within the confines of legality, due process, and respect for fundamental rights. That is our position and that is our guidance. And as I conclude, we do not intend to stop here. We still in exercise of our mandate, which is statutorily given or granted to us. We intend to still engage the stakeholders in this field to ensure that the public benefits from, this kind of legislation and the laws that are being passed, instead of the same being, more punishing and punitive and raising an uproar like we've had. Again, as I conclude, I thank you very much. I know our time is fast spent here. Please keep on looking out for our Rnblive events, because they are not only educational, but they're impactful in as far as we do contribute to the very basics of the rule of law and good governance in this country. Thank you very much and have a good afternoon. May I take the honor to invite our speakers for a group photo? Yes. It is part of our tradition. This is the 22nd Rnblive, 22nd. Yeah, so we keep record of this. It is very good to document. want to keep memory of this day. Yeah, no, it's okay.